And again, we're able to track Mr. Robinson when he leaves this parking section.
Hands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Oh my
You
gosh.
see Mr. Robinson
Can
now.
you hear me now?
I do, yes.
Can
He's
you
just
hear me
arriving at the
now?
corner of the building. Almost the top center.
Oh,
of
can
the
you hear
image.
me now? Hopefully you can hear me now. Good morning. Good morning. We are tuning into day 2 of the Tyler Robinson, like state versus Utah, state of Utah versus Tyler Robinson preliminary hearing. This day 2. I was sorry, I was a little bit late. I had some stuff going on. Obviously, I had some technical difficulties tuning in as well. But all I basically said was please hit that thumbs up if you are just popping in, and also subscribe if you're new. This is obviously the bestest channel ever, and I'm trying to reach 1 million subscribers by like next week, so every little bit helps. And I was just looking at some other streams going on out there. I tuned in late today, so of course everybody's at everybody else's stream, but obviously if they would find mine, they would realize it's the best one. There is, you know, the Sausage Fest over here on Mr. Lecco, Danks, Trigger Smart, Jesse on Fire. They did not invite me to their Sausage Fest to watch the stream with them, so I will be here all alone. And it's much better over here, okay? Nobody likes a Sausage Fest. Okay, you know what I'm saying? So here we are. Hello, hello. What's up, Not Nancy? And I'm gonna say Gil. I don't know if that's how you pronounce it. Snoops, Brian, Jeannie, welcome in, guys. Did I say hi to Not Nancy? Yes, hi, Not Nancy. So yeah, here we are. And we're just looking at some video.
It's on
This
the-
is apparently Tyler Robinson cruising around town. This is all the video they have of him cruising around. So we're checking that out.
Now, what do we see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle
how
was
Allie
stopped,
feels
it
too.
actually made contact
I don't
with
blame
an
her.
officer who was
Tell her to
doing
come over
security
here.
detail.
Okay, and do you know who that
We'll have a
officer
way
is?
better show
Officer
than the
Goforth.
guys.
Okay, and do you know which department he works for?
100%.
Spanish Fork, please.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
Okay. On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during, I guess during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle, and then subsequently, when information was available that that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information?
Yes, he ran a partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes,
And did he tell you who the owner of that vehicle was?
he did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Interesting. They've got proof Tyler was driving a car.
Let's return again to Wispin Mark Stakes Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or Wispin Mark Stakes Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay.
My
I think
goodness.
there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
Probably
I
red
believe he's
highlights, I would
referring
guess.
to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Something different?
Permanent or temporary?
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And this is a bad question. What I mean by
Hi,
that
cheesy
is do they
brats.
appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come
morning,
off the video.
good morning, Jen.
But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of
Like,
of
is
interest.
this for real?
within
Oh
the
my
video.
gosh.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself, as far as its
Not-
accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been
Cheeky
mentioned,
man,
that we talked about,
hello.
is there's some blurring.
Yes.
Do you know what that, tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage, and their faces were blurred.
Is
Excuse me.
anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
Why don't they just watch it if they want to ask all this stuff about it? Like, he's asking them every detail about this video. I think basically the people just want to know its authenticity. Like, you know, who created the edits on it? What day were they done, etc. He's asking every little stupid detail of things that you're obviously going to see when you watch it. This is ridiculous, crazy, like boring. Come on, guys.
That's in 12.1 that has been removed.
What else do the
yes.
circles do? They reach
What
out
can
and
tell us
smack you
about
in the
zooming in and
face.
zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that
suspect.
particular footage was zoomed
He's like
in for
Mr.
clarity.
Robinson. I guess this isn't
other than
very.
zooming in and zooming out.
This isn't very like precise. They can be very lackadaisical with their explanations, and they can say things like, yeah, it's Tyler in the video over and over and over again because they're not in front of jurors, I guess. So we have to excuse some of this, but my goodness, no wonder these lawyers get paid like big bucks. You know what I mean? No wonder. And yeah, they weren't allowing it, but evidently the judge was looking at it anyway. So, I mean, if the judge is going to look at it anyways, why the hell not, right? But no wonder these guys get paid so much money. I could not do this all day. I couldn't.
Away from that video.
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the Losi rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
4. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the
Is it fair to say it's far away? And so is it fair to say that zooming in brings the image closer? And why do you think they did that? What else did the zooming in do? Does it also reach out and smack you in your face?
combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted to evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other
He
two.
always has to get the last
Again, Judge, we
word.
believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question, in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4
Well,
words,
I
unless
can
you
read,
want to share that
I
with
can
me.
read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may, let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the two videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision, or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it simply, it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right, well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again.
Then why in the world is he going to watch it if that's the interest of justice? And I love how he says it's not cumulative, but it's literally Tyler Robinson, different clips of Tyler Robinson over time and enhanced. So, like, it's not cumulative at all, but you know, it is over time and it is enhanced. I mean, I don't know what you would define cumulative as, but
it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And
Jeez,
your
oh, man.
intent is to review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge? Or maybe one request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really
he really wants this published. He really wants the public to see that.
the thrust of why we are trying to introduce that exhibit, because
I see.
we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way rather than just present it in its raw form and then.
He's like, there's no way you could zoom in there's no way you could zoom in on it, but we did, zoom in on it and preserve it for you. So you can zoom in on it because you did zoom in on it, but you're just saying you can't zoom in on it. This guy is crazy.
Have the ability to zoom in and out, if that helps Your Honor
Oh.
understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in, how long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right, thank you, I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at. So all parties can see clearly that the court is reviewing it in court, but I do not find that it is necessary for its publication because this is the exact same video. I recognize it's zooming, but in balancing the constitutional rights, there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Council's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's
I knew he wasn't going to shut up.
natural break where we can start. And what I'm going to ask is just we simply play the you will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I
Okay.
will. All right, whenever you're ready. Council, as it relates to your monitors, just as a caution, if you don't want,
He's like, whenever you're ready to shut the hell up, we'll go ahead and view this video that we're not going to show the public. And he keeps asking them to show it anyway. Well, Your Honor, I think it's important to show the public. I think it's important to, like, you know, no notification, honeybee. What the heck? Yeah, I put this one up I want to say half an hour before I popped up live, so I apologize. I was late coming in today. I apologize. Yeah, I don't know that this is a video of the actual shot. I think it's just a video of him run like the suspect running around on the roof and running and jumping and doing all these things, and they just put all the videos that they've already showed together into one video and zoomed in on things. I don't know. It's just crazy. It's crazy. Oh Lord. Zoomed, he's nuts. Yeah. Yeah, I have no idea. I think they have a video of somebody on the roof they want to zoom in on, but I doubt that I doubt they're gonna see it. I mean, it's not clear. They would have been shown that forever now. Painful Truth, thank you so much for the super sticker. Thank you. I really, really appreciate that. Helps me out very, very much. Appreciate the tip. Yes, feel free to tip your host anytime, guys. I would never turn down a tip. Derek, also, if you want to go to the full screen version where you can see this a whole lot better, you can actually just, if you're on your phone, turn it sideways and see the whole entire screen, the court and everything. The link is pinned in the chat, and it's also at the very top of the description of that video that you're tuned into. That goes for anybody on the vertical version. I did put up both just so people could find it, but you can click that link and come over to the bigger screen version. You can see my beautiful face a lot easier. All right. Allegedly, F you, allegedly. Yeah. And the members,
Oh, I
feel
see.
free to use
No,
the
it's-
stickers.
limitations of technology sometimes. Thank you for letting me know.
Yeah, exactly. Not Nancy. You can read the license plate info to identify who it is, right? Even though there's a couple of different people listed as owners of the vehicle. And I don't know about you guys, but I've driven vehicles that I didn't own before. Have you?
6-minute mark, Judge.
Anybody in chat driven a
right.
vehicle you haven't owned?
So
Let
for
me
it's
know.
clear, this
I
is
know it does happen.
4.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hull, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it.
G-Key, we could literally play that on our phone and zoom it in. So they're just don't need no fancy smashy stuff. I guess if they don't, have it on a phone though. But he's lying when he says it can't be zoomed in, because it sure can. This is 2026. Let's go. What's up, Era? I never turned down a tip either, right? Who's gonna turn down a tip? I appreciate those. Yes, thanks for joining us today. Hit that like if you are just coming in, obviously hit the like button, subscribe if you're new. We're making our way to 1 million subscribers. So any day now, like probably in like 2 days, we're going to get there. 2-3 days max, you know, max. I don't know what they're doing. They're having a D's Nuts festival over here in the courtroom, I guess. And we're gonna have to try to beat out Mr. Leco's stream. He's got 80 people watching right now, and we've only got 30. So let's share out the stream. I really want to beat out this sausage fest today. I really do. I want to just slay the sausage fest. So let's share the stream out. Let's get our friends over here. You know, moms, dads, BFFs, buddies. Just be like, hey, even if they turn it on and set the phone down. Know what I'm saying? We're way more fun than they are. I mean, look at this courtroom. The volume's all the way up. They are literally not even talking right now. Do you guys see my video I did about the Candace stuff? I put all those text messages in one video. I ended up redoing the video. Even though we did it here on the live stream, the screen was too cluttered. So I wanted to make it better.
3 seconds.
I fixed it up.
Judge, at 8:23.
Candace went in on Andrew, bro. She bitch slapped that fool.
Thank you.
Okay.
She just bitch slapped the hell out of him.
Thank you, Mr. Sturgill.
Yeah.
Agent
Injection.
Holt, you were able to watch that zoomed in version. Is
Yes,
that
sir.
right? Okay. And
It is not, Jen.
was
It's
there
just a regular
anything,
one.
that stood out watching that zoomed version?
Right?
For me, on the zoomed version, it's apparent that Mr. Robinson, the
They know
individual
where I'm
jumping off
at.
the roof, is carrying an item.
Okay.
They want to be
And you can
haters.
see
That's
clear,
fine.
The clothing that he's wearing.
Sharing is caring.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Well, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Holt.
He has nothing further.
Ms.
Hold
Nestor.
on. This is a monumental development. He's finally shutting up. It's only been 2 days. Nothing further with this guy. Is he looking at his wiener right now? What are they doing? Did he place his wiener on that notebook and she's staring at it? Like, what's happening? Why are they chatting? What's going on? What's happening? He's like, make sure you don't ask him anything about the video.
And I was going to suggest that it seems like right now is a good time to take our morning break. It is 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Holt.
I
Court is
love
now
her
in recess.
cross-examination. She did such a fabulous job yesterday, in my opinion, allegedly. She did such a great job of just basically making that witness get all nerve-wracked and everything. So I hope she does it today. This guy seems like he could be easily nerve-wracked as well. You see, he seems like one of those people that gets like, so I can't wait to see it. I'm here for it. Can't wait to see it. Really can't. I forgot to go through my 8-hour live stream yesterday and pull out all the times she objected. I just couldn't do it. I just didn't have enough energy. Do you know when I ended that stream, guys? Listen to this. I ended that stream and I sat here for a moment, just like in a daze. I was like, literally, like probably even drool came out. I was just like, did we just do that for 8 hours? Holy shit. And then I stood up and I went to bed. I got up at 2:30 this morning though, because I went to bed so early, but I couldn't. I was just, my brain was completely and totally just fried. And yeah, it took me a while this morning to make that video for you guys about the whole thing with Candace, because I went through and I actually pulled the clips and made the video with the stuff I had from the live stream. And then once I watched it all together, I was like, this is just too busy. And it just was too annoying. So I ended up redoing the entire thing. And then that took me a while to edit. Then I had to help my mom, and it just went on and on. But it's been a long day already. So at 2:30, I've been up for 12 hours already. But yes, thank you everybody for being here. We're on a break from court right now. We're on a break. And it's about to be a cross-examination. And let's see, this is Brian Enton from 5 hours ago. And I wanted to see what he was saying, because he got some great footage, I guess, outside the courtroom as well, and was talking about some stuff. Let's see if he has anything interesting to say. He's always pretty on point about things. So let's see.
Really appreciate it. Please click to subscribe. I'm here in Utah. This is the courthouse right here where the Tyler Robinson hearing has been ongoing. He's, of course, the man accused of assassinating Charlie Kirk. A ton of new developments coming out of this hearing.
What in the world is he walking past right now? Like a whole entire thing. We're going to get way past that. I don't want to hear that noise.
Utah also, but it's brutal out here. It's been an emotional day inside the preliminary hearing for Tyler Robinson. You know, I've covered most of the hearings in the past with him. None have been as significant as this, but it's always just been Tyler Robinson's family in court, his parents. And there's just a whole different vibe today, obviously, with
I want to
people
see
there supporting Charlie Kirk.
There's the skank. Look at her. What is it with her security? Are they freaking clones? Do you see this? Do you guys see this? What in the hell is this? It's like the clones guarding the clones. Is this the Clone Wars right here? It's like an older clone and a younger clone. It was like this old guy was like, when he was 20, he said, clone me. And they made a clone of him. And they're both bodyguards. What's happening here? Oh my gosh. And then we've got the clone of Erika Kirk who's mad all the time. It looks like, maybe, because this doesn't look like the sad one. This looks like the mad one. Maybe. I don't know. I'm not sure which clone of her is here right now. But what's up with the clone bodyguards? This is weird.
Never seen before. His wife, Erika Kirk, is here. This is her first time here.
His widow.
His parents, Charlie Kirk's parents, are here. They're all sitting in the front row.
And let me say, who in the hell wears 85-inch heels? Look at those heels. Girls, how many inches are those heels? Would you guess? This is a bougie bitch who can wear that kind of heel to a courtroom and be out here all day in that shit. That's crazy. Okay. Only bougie ass bitches wear these, 4-inch heels. At least. They look ridiculous. And she's just, trompsing around in those. She probably is one of them girls who doesn't even take them off in the car because she's just ready to go. 5-inch, 22 inches. Yeah. 22-inch heels on this girl. I just cannot. 22-inch heels, clone bodyguards. I'm so confused.
And we knew that. I reported last week that they would be here. But what we didn't know and was unexpected is Don Jr., President Trump's son, is also here, sitting in the front row right near Erika Kirk. And he's here with his wife, which is just, you have the president's son here. It's striking with them all in the front row. It's a different vibe in court than at past hearings, obviously. And even the judge started the hearing by saying, acknowledging that Erika Kirk was inside the courtroom. And it's always awkward. Like, I even remember when I was covering Koberger and the victims' families were there. It's just always awkward because everyone's so close together. I mean, you've got Erika Kirk, and then you've got Tyler Robinson's parents not far away. It's not a huge courtroom. It's not a small courtroom, but it's not a huge courtroom. And then you've got Tyler Robinson sitting right there. And you just imagine, an emotionally filled courtroom on all sides. Erika Kirk was emotional from the beginning. She actually left the courtroom several times in tears, which we knew, they would give warnings before certain parts of the of the testimony when they were going to be very specific about describing the shooting and the assassination. And she actually left and went outside emotional. She didn't want to be there for those parts of it. It's interesting because you're able to obviously see the witnesses, which have been police officers up on the stand, but when they play the exhibits, like the videos, there's different angles of video that capture Charlie Kirk being murdered, some which we've seen, which have been on social media, but then also there are some that we have not seen. They acknowledge that there is an HD video from Turning Point USA that they turned over to investigators that was played. But when they played these videos in open court, and I've never seen this before, they didn't show anybody. Even if you were in the courtroom, you couldn't see them. They didn't play them on a monitor. They just played them on the screens for the judge and the attorneys, but not in a way that anyone watching inside the courtroom could actually see them with their own eyes, and not in a way that obviously the camera feeding out the video for the stream could see. But even in the courtroom, the people sitting there were not able to see the videos, which I've never seen it done that way before. But it was almost more intense in some ways because you could see Judge Graff's face while he was watching the videos, and he a couple times almost looked shocked at what I'm assuming is the point where Charlie Kirk was shot. You can see it here in the video. At one point he just kind of looks shocked, and everybody kind of noticed that in the courtroom. I want to play for you a couple of moments though from court that stood out to me with the police officer who was on the stand. This is a Utah Valley University police officer. He talked about right after the shooting when they were pushing people out, and he actually noticed an empty pistol holder in the grass, separate from Tyler Robinson and the rifle, but a pistol holder in the grass. Listen to this.
And what's funny about that holster that he found is you've got to ask yourself, you realize when you have a holster on you that is to, carry your, what on your hip usually, or, across your body, however you carry it. They didn't specify, but it's to carry this thing, right? And so if you drop your holster, that means that you've got this thing now, in your pocket, in your hand, in your purse. Where did you put this thing now? And I thought that they did find somebody with a, what? Didn't they stop somebody that had one, a hand one? And I don't remember what happened with that. Maybe they didn't, but you've got to ask yourself, what happened to the person, and how do you lose your holster? Because it's on your belt. Your holster's on your belt, or you have it on a little shoulder thing where you kind of it's like a little rope vest almost, and you have it it holds it there. I mean, it's one or the other, or it clips on in some way, has a clip. So it's where did that thing go then? So you're running around with it in your hand, in your purse, what? It's just crazy that, they find that and don't even just ignore it.
This.
Was your attention drawn to anything else at that time?
Yeah, so after we got some people kind of cleared away a little bit, I thought I needed to start preserving the scene because we had a crime scene.
That's
going
a
on
joke.
Okay.
So that was interesting because he saw the pistol holster, but knew that pretty quickly knew that the sound of the shot was not from a pistol, but was instead from a rifle.
No, let me ask, could you guys tell the difference between those shots? I mean, maybe if you are an avid user of one, you would notice the sound was totally different. But I found it strange that he didn't realize the sound was not that until he looked at the holster. We remember hearing him say, he saw it there. He was trying to preserve the crime scene. He sees this and he goes, oh my gosh, you know what? That sound wasn't from a hand one. That was from a, what? And that's when he realizes that sound was correct. Okay, thank you. Because I don't know that I could tell, especially in a crowded area where you're focused on listening to a speaker, right? Everybody's there to listen to what Charlie Kirk is saying. So people are really into what he's saying. And then the sound happens and it's I don't know that I could tell right away. Even if I knew the sound I don't think I could differentiate that at that moment, because when you hear that, I imagine you start panicking, right? Because you're thinking somebody here has a, you know what, and they are using it in this crowd, and you start to panic. So you hear this and you immediately panic. But how do you say to yourself, like, oh, that was this kind, not that kind? I just don't know that I just don't know that I don't know that I believe that. I don't know. Maybe, but I don't know. I imagine it would crack way louder than a regular hand one, but I don't know that I could, in that moment of being like, oh, in a tizzy, recall the sound of that and notice that it's different. I just don't know. And I don't know if Brandy and Billy are still together. I don't think they are. I don't think they are. I think Billy's there. Brandy's there. Brandy Cicilani's there. I think Kelly Raybon saw her yesterday. I don't know about the other one. I think they split up, but I'm not really sure. Oh yeah, okay. No, Brandy and Billy are no longer working together. Okay. Wonder why. Wonder what happened there. Anybody know this story with that? And when Candace played the sound of a shape charge, it sounded like what was heard. Okay. Interesting. Sometimes sounds like fireworks. Yeah, I mean, I know that you would probably recognize it as something like a what, but I don't know that you could be like, oh, that's not this kind, that's this kind, unless you weren't maybe in a panic and you were listening to it and somebody said, hey, what do you hear? I don't know. Yeah, do not believe anything. Yeah, I agree. Right. Yeah, to look at that and be like, yeah, it was that. That's what I'm saying. That's a little weird to me. Little weird to me. So I don't like that story. I think that was ridiculous. The judge probably thought it was too.
And they talked about the confusion because you remember initially they arrested the wrong person. There was an older gentleman there who they arrested, and they thought they had the person in custody for the shooting pretty quickly, but it ended up being the wrong person. It was someone up close to near where Charlie Kirk was shot. And the defense attorney asked the officer, well, because he talked about how he thought that they had the person in custody, but the discrepancy there was, well, if you thought it was a rifle shot and that pistol holder was not the pistol holster was not from the person who shot Charlie Kirk, then why were you relieved they had someone in custody? It just sounds like it was chaotic in that moment, very chaotic afterwards, and they soon realized that the person they had in custody was not actually the person who shot Charlie Kirk. But the officer described in detail, and this is one of the parts where Erika Kirk left, what it was like hearing the gunshot and then seeing the way that Charlie Kirk reacted.
So you mentioned you heard.
Yeah, I don't want to replay all those talking about that. I just want to hear what Brian specifically has to say. We saw this yesterday, so.
How much they love Factor, and I'm just like, I told you guys.
Oh, this is a commercial. Okay. I thought Brian was telling us some cool stuff.
Bite from court where the police officer described it, but essentially there was no backup agencies involved. There was no drone, there were no metal detectors, there was no one that scoped out the roof or the walkways around where Charlie Kirk was speaking ahead of time, and there was no plan. They didn't meet before with a plan, according to this officer. Listen, the defense attorney kind of zeroed in on some of these things.
Yeah, we saw that as well. They zeroed in on that and said, what was the deal here? I mean, as far as I can tell, they did have that walkway, that breezeway above Charlie Kirk covered, which is what Brian Harpole was harping on in that interview that he did with Sean Ryan. Remember, he was saying it was all their fault. It was all their fault, talking about law enforcement. However, the text messages that he showed were about that breezeway. They weren't about the other roofs around the campus. They were about the breezeway. And we saw that they did have it covered, and this guy as well admits that they did have that area covered, so I don't know what Brian was talking about and harping on that area for. I think he was trying to, in my personal opinion, allegedly, I think Brian was trying to get us to think that they were discussing all of the roofs around the area in that text message exchange that he showed us, when in fact they were only referring to that little breezeway, which they did in fact have covered, So I just like Brian Etton's take on some of these things. I don't want to keep having to hear him say pew-pews and things like that, because that's all stuff we're not really supposed to be saying. He keeps saying it over and over again.
Covering what or anything like that?
So that part again really, really shocked me, just because I would have thought that with someone of Charlie Kirk's notoriety, there would have been more of a security plan in place. There would have been outside agencies coming in to help. There would have been backup.
And the fact that they had nothing of this, right? Nothing of this sort. Nothing of this sort. They literally deny having any type of other agencies backup. They, like Brian said. However, the feds were there on the scene pretty quickly after it happened, weren't they? So it's strange to me that they had no type of anything, and then the feds show up. Like, I mean, I don't know. I've never had to call the feds, but I know at least when you call the police, takes them a minute to get there too. So it just is, I don't know. It's a little bit weird that the feds would be there so quickly, even if they weren't involved, weren't involved. Jostle, I think it's Jostle. I apologize if I'm saying that wrong. Jostle says they were 12-inch heels. What happened to the mountains of their evidence? Well, we're only on display, or what do they call that? We're only on like number 3 or 4 of who they have. How many items were they showing so far? They were like evidence 6.2 or whatever. I don't know. There's supposedly 40 to 50 items I think they had to show. And we're only at the beginning. We're not even to 10 yet, I don't think. Or maybe we're at 12. I can't recall. Donna says first live. Well, welcome in, Donna. I hope you enjoy it. And at least stay awake. My goal here is to keep you guys awake and find out what evidence they have. That's the goal I have. All right. And it's to beat out these guys over on Mr. Lecko's channel. All right. We're trying to beat those guys. Okay. We haven't yet, but we're trying to beat them. I don't know what they're watching at. I think they're ahead of me somehow because mine doesn't show that they're back in court yet. I don't know why. Yeah, it's not showing back in court yet, but those guys actually see it. They must be watching a stream that's a little bit quicker than ours. But that's the goal today, to keep you guys all awake and to get us on point and get this information. And of course, beat
Go
out.
ahead and pick up where we left
the
off. I note
sausage
that the
fest.
parties for each side are present in the courtroom.
Here we go.
And we are picking up with
The second goal is shit because this hearing is garbage.
This necessary, your witness.
May it please the court. Thank
Extra
you.
caffeine.
Good
Good
afternoon,
idea.
Agent Hall.
Good
You and
morning.
I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson.
Okay, girl.
So
Get it. Get him, girl.
when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that, or were you not
It's
involved in
not,
that?
no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene.
She's setting him
Right?
up for something good.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured, and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my
What?
time there on September 10th, yes.
Which building was that, sir?
Oh
I
my
don't
God.
Was that considered a scene that was worth preserving?
It was not. My
Wow.
recollection is that that was accounted for
Oh,
as
you're
an
fucking
ejected
kidding me.
cartridge from an officer who had cycled his rifle.
Right. Why would he
Okay, I thought
cycle
you
his
said it was
rifle?
a unfired bullet, and now you're
That's-
saying it was a
that's correct.
cartridge?
When a weapon is cleared, an officer would make his rifle ready, which would chamber around.
Oh, I got you.
It's- My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
Wow.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you?
Correct.
Wow, dude.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun,
Any other guns that were found on the scene?
not that I recall.
My God, this shit's
Do
crazy.
you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. that refresh your memory?
I know that a trooper was interviewed, having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay, and
I'm in shock right
just a
now.
moment, Your Honor.
Oh my God.
And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I
What?
do not.
Another
You do not?
one?
No.
Oh my God.
Okay.
Wow.
Can we pull up?
Insane. Oh my God. Oh my gosh.
Exhibit hole 13 and just show it only to the witness for right now?
This is insane, guys. This is so crazy. Holy shit. Oh my gosh.
All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a
No.
report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there, there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, do you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline, is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
Looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So, as of September 14th, Tyler Robinson had already turned himself in to the authorities, is that right?
Yes, I believe he turned himself in on September 11th.
So, Prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was? Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay.
Wow. Wow.
And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation,
Okay.
or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself, you all had not been able to determine that, is that right?
Excuse me. Determine who he was, or
No,
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the?
Correct,
From the parking garage.
correct.
But the video on the roof was not distinguishable, fair?
That video as a standalone
Yes,
was not, no.
okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video, is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been else. But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event.
Okay.
If that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting he was holding a gun in his hand?
As he crossed the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah,
No.
all right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay,
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
okay, thank you.
Wow, for never having, played that out or done that before, that's pretty quick.
All right.
Pretty quick.
I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr.
Are
Kirk.
you referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull
He's
up
so uncomfortable right now.
the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Yeah, sure.
Oh, it's because they're showing the video, I guess. This is wild.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you.
She just wants to prove you can't see it. That's all. Because this douche isn't answering it. Oh, I can't confirm that when you're standing behind a building. She's like, well, bitch, I'll make you confirm it.
Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was
you
no one
see?
standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Wow. And he's an
I can answer that
officer of
question if I
the
can hear the
law
video
somehow and doesn't recall. He
And
should have
just
noted.
before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Just real quick, if he's an officer of the law in some capacity, he should have notated a ton of details from that one video in a 10-second clip or whatever. That's literally what they quiz you on in the police academy. And he's like, oh, I wasn't looking for an actual person back there. Well, what were you looking at, sir?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right,
Yes,
She's
behind
saying in the
tent.
middle.
correct. But
How hard is
directly
it
in
for
the
him to
middle of the tent,
understand?
is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you.
Okay. And I want to know,
All right, I
why
wanna
is he so nervous right here? Like, why is he so nervous? He's so nervous you can hear his mouth going. It's gross because his mouth's so dry because he's so super nervous. And what I don't understand is why. He's just answering questions as to what he saw and what he dealt with that day. There should be no nerves involved. He's not on trial. They're just asking him simple questions like, what did you observe that day? He's being very weird. And he's like, the videographer. Like, she sat in the middle. And you can't notice a part, like, you don't remember seeing a person, but like, that's just crazy to me.
Talk now about the TP. You can take it
Crazy.
down off of the screen. Thank you. I want to talk now about the TP USA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
Tony
The
says
visual impulse
Ben
video?
Shapiro's
Yes.
eyebrows
Yes.
running around
Right.
the city.
Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay, so you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right?
I love how she's switching up on different things. This is a great tactic as well to keep him like off balance. She's like, let's go to the autopsy. Let's go to the Ring camera. She's really keeping him like ping ponging. And when you are telling lies, it's hard to do this when it's like a ping pong to the next subject. And now he has to download all the information from the ring camera lady now. He's like, shit, God damn it.
To get that ring camera that we watched with the car on
Chugged
the
his,
outside?
chugged his water
She-
for 10 minutes.
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble, yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole? Sorry, just a moment. Let's see. Whole 48. This is Miss Noble's interview. Do you have it? All right, do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that ring camera, did you?
Wow.
I did not.
And did they also tell you there were 3 other people in the car?
Wow.
Yes, I believe they thought that was the case.
You forgot to mention that too, didn't you? Wow. This is crazy. Oh, shit.
I want to go back, if I can, to the scene.
Oh, my God.
The scene itself, the preservation of the actual scene where where Mr. Kirk passed. Did you all
She's
have
switching
canine
again.
dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent,
Me, personally?
Right.
No,
so you're not sure when it was removed?
no.
And were you involved in the decision to pave over the dirt that was under the tent?
Oh,
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct?
You received tips of death threats that Mr. Kirk had received the day before the shooting. Is that right?
I'm sorry, did we receive
See?
threats that Mr. Kirk had received before the event?
she's got him all
Let
confused.
me clarify. That
Thank
was a
you.
confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I don't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
You know what? That she shouldn't have let that go either, because he didn't take responsibility. He turned himself in because they were looking for him. He's like, he took responsibility. That's not the case. Just because he turned himself in doesn't mean he took responsibility at all.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in.
Big
In
surprise.
terms of what you've described, I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
Of course he has to redirect. He always has to have the last word on everything.
Just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have
Possibly.
maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of, if on the 10th, there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently, specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that round was from an officer clearing his weapon, what exactly do you mean by that?
We
Our
heard what he
standard
meant by
practice in our
that.
department is to carry a rifle cruiser ready, which
I'm
is,
sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of,
But wait a minute. After that is done, and don't you have to like account for every bullet that is in your weapon? Don't you have to account for every single one? So how would they just miss that and not have that written down somewhere? Where's the account? Where's proof of the account of that missing bullet?
Is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars, so I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
That is such a good question. You would clear it when you
I'm
get
gonna ask
back
you
to the
about,
vehicle.
Ms. Nestor asked you about
Or good comment. Why would you clear it on
your
the roof?
observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Can you be more specific or describe in more detail
It
what
appears,
that item
it
might be?
appears to be black, and it appears to be longer.
Okay, anything else about that item?
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video, is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner
Sure,
in that tunnel view.
yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay, and
You're referring to the back of the pop-up tent?
correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
Right.
and you cannot see through it, no.
it? And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see.
How
You would not be
much? He
able to
wants
see
to know
through
how
it.
much.
You would not
Was
be
he
able to
supposed
see
to say
through it
5
from
feet?
the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Dude, sit
You-
down.
Well,
You had a chance
we exhibited,
already.
or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at, is that right?
Correct.
And leading up And again, I'm referring to that view, that tunnel view of that surveillance camera leading up to the shot. What's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA, there are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the?
They appeared to be the same.
I've
You're aware
recognized
that
a
a
tree.
rifle was eventually discovered,
Yes,
and was it your understanding that that rifle was discovered in a wooded area?
it was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered in the tent?
Yes.
Funny how he knows all the answers to the question this guy asks, but he doesn't know anything when Nestor comes up to ask him stuff.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event.
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so.
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes,
Okay, so identities of possible shooters.
correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes,
Okay. And that was the Washington County Sheriff's Office.
yes,
Okay. You understood that he showed up there voluntarily. Is that right?
correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further.
That was the dumbest thing I ever heard. He's still got shit to say. Like,
In the video that we've already
This
talked
guy
about,
up
the
here
video
on the
where Mr.
stand now, I
Robinson
feel
stands
bad
up and
for him.
runs across the top of the Losi building. Is there, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position
Correct.
and then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
I hope she crosses again.
No follow-up, Your Honor.
No,
All
she
right.
won't.
May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you.
He's like, praise the Lord.
Just a minute to
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
Goodness gracious. I'm going to tell you what. That was crazy. I can't believe they found all the stuff that they found. We never heard about any of that stuff, did we? They kept that all airtight. I am loving it. Somebody said someone in Gary's stream is asking, why would an innocent person turn themselves in? Probably because he didn't want to get unalived by the police, especially after he heard there was some type of self-unaliving section of the supposed note that he supposedly wrote. I mean, if I heard somebody saying that, I'd think the same thing. They're coming for me. They never planned on this. They never planned on him, whatever, all right, so let's see. The Sausage Fest is down to 4. There's only 4 left. We've got 86 people over there on their stream. And we've got 72. We did have 86. We matched them. So make sure you hit that like button so we can get everybody over to the stream here. The more you like it, the more you talk in the chat, the more you hit those little hearts over there to show some love, the more YouTube decides to share the stream. And we definitely want to, we want to win today. We want to be winners today. This is a boring ass trial. It's really hard to keep us entertained. I'm trying my best, guys. I really am. Hang on, I got some music we could put in the background. I forgot about that. We could just be jamming and some music. Turn it down so it's not blasting in our ears. Yeah, it's crazy. I can't believe they had all this stuff and we never heard of any of it. That's wild to me. Dude in the pic was a Fed on loan from the Fed white nationalist crew. These people were complete clowns. Yes, they ignored evidence that didn't go with the narrative. Exactly. Remember that? Yep. Oh, thank you, Robin. I appreciate that. Idaho 4 is total Fed slop. We're going to have to look that up and see what's going on with that. The Idaho 4. I'm going to actually write that down. Take a look into that. I can't stand when he cross-examines that guy. Yeah, guys, this is terrifying when this just becomes more and more Fed slop. It's terrifying because it just means that it's coming down on us. You know what I mean? It's coming down on us, and I don't know. There's going to be just more of it. The more you hear of it and the more we let it go, the more it happens. And so this is kind of scary to listen to. There's more Fed slop out there, Is I'm in shock. I'm in shock that they found an entire holster. They found an entire, this thing here. And nobody mentioned any of that. I just can't. I can't. Yeah, they're counting on it being boring so we don't pay attention. Bootsy is right. Also, Bootsy, if you want to come over to the full screen stream where everybody's chatting, if you can hit the link that's right there in the top, very top of that video description, or it's pinned in the chat. If you hit that link, you can come over to this side and you can see everything a whole lot bigger. It's a lot better, but I do like to make a little little vertical stream for the people who are over there. Also, guys, if you're new, please subscribe. We were trying to get to 1 million subscribers, probably Saturday. We're gonna say Saturday. We're gonna hit the 1 million mark. Yes, even the evidence they do have was barely investigated. I agree. The feds know they're not selling it, but they persist, which is just incredible. Yes. Yes, please like, share, and subscribe. Yes. Yeah, I think so too, Jen. A lot of what happened that day did not go according to plan, and they are just scrambling to account for things. Yeah, exactly. Yeah, data centers and stuff. Yep. Yeah, I'm just in shock about that, guys. I really am. Maybe we'll switch back and see what Brian had to say about pre-trial stuff that he was talking about. Actually, give me a second. Let's just see what else people are saying live. This is not. Kelly's watching live too. I think Kelly's there though. She might be in court today. She said she was gonna get into court. I don't know. Who else is streaming this, guys? Anybody know? JLR Investigates is streaming it. He always has a ton of people watching his though. He's got like 5,000 people watching his. But he has like millions of subscribers. Nope. I'm trying to see it. Man, nobody else like funny is watching it. Nobody else fun. Just me. Just me and Kelly. Kelly's kind of fun too. But oh well. Yeah, let's check in Trigger Smart. He's on the one with all the guys, which I have dubbed the Sausage Fest because it was all dudes. There was like 6 of them earlier. I think Trigger Smart was on that one. Valhalla was on that one. Yeah, Valhalla's funny. People said Valhalla's funny. Allie is. Let's see. Allie. Gary. Let's look at Gary. Paramount Testicle. And he's way behind us. He has that same guy. Or is this from yesterday? No, this is today. He's behind us though. I want to get to where they're at a break and we can hear what they're saying when they break. I guess it just depends. Some of these guys are way behind us. All right, you know what? These guys, let's hear what these guys are saying over here.
If he talked to somebody at Turning Point USA, and
Nothing, but it would be super interesting.
Who would? But how do they know that that person was from Turning Point USA? Like that was so weird.
I don't know.
What is?
Yeah, that's. Yeah, I'm sure they'll come up
Where
later.
did that come from?
Well, we'll probably find out. They wouldn't have brought it up if it wasn't going to be.
Did they have a separate booth or something?
They have people over campus handing out flyers and all that kind of stuff. Jay Jennifer, thanks for the super chat. Please allow this in evidence. Any lawyer would have a field day with this footage or lack thereof, it being Tyler. Yeah, I mean, you have to prove it's him. Whoever this person is looking down in a way. They have sunglasses on and the hat pulled down. Clearly, they're avoiding the cameras. That makes it a lot more difficult to prove it's him.
Yep.
It's Blakey. That's a good question.
In the video of Tyler, not Robinson, that's fake ass limp. He covers his face sometime before this. Someone made the exact route and pointed out the cameras, same at the parking lot to be seen. It's very, like Matt just said, very clear that he was whoever that is, purposely did not want to be recognizable. So,
Lori Nelson Posner, thanks for the super sticker.
Yes, they did, guys.
Nikki Rock says, "Where are all the screaming students fleeing?"
Hang on. These guys did too. You know who streamed it? These douches right here. These douches right here. Let's get rid of their chat because we don't care. Let's see what they had to say. Right here when they were
Closely
showing
building
this.
onto the grass area and then moving away towards Campus Drive.
So the guy with the limp suddenly became a lot more mobile right there.
Right after 12:23 and
A lot more mobile. He became a lot more mobile.
28, which is, as we all know, the moment. So,
Does Andrew Colvett ever wear anything else? Does he own another fucking outfit? Like, really? Does he own a single other outfit, or does he always wear the same clothing that makes him look like a talking dick? Well, Blake looks like a talking dick more than Andrew, but Blake literally looks like a talking dick where Andrew just emits the energy of a talking jerk, which I equate to calling him a dick.
It's hard to watch, to be honest. So I don't know. Anybody else want to chime in here?
It's hard to watch them point out on a map. Like, come on, Andrew. That wasn't hard to watch. What's hard to watch is the videos that are going around with Charlie being happy and enjoying his life and loving his life. This, where they're just pointing out areas on a map, isn't hard to watch.
Yeah. I mean, I remember that footage. That footage, at least that little bit of security footage, that was published I think that was published all the way back 48 hours after the shooting by the FBI when they were looking for the guy and they were sort of presenting the evidence of why they thought this was the guy. Maybe it was at the apprehension. I'm not sure. But I remember that footage, and I thought it was, perhaps one of those things where once you understand that it's like, oh yeah, clearly it's this person, right? Like whoever, you have the timing in the background, that's when the shot just happened, and then you have a guy scrambling across the roof and dropping himself down to like clearly escape.
Clearly, that's exactly what happened. When you hear that happen, and then you see somebody running, clearly that's what happened. Clearly, that's 100% what happened. I mean, clearly, nothing else in the entire world could be going on. There's nothing that could be going on other than that, especially when the feds say it's true, especially when the feds are like, this is what happened, then for sure that's what happened, because it's clear.
Like if he was, a normal person, say just again, like let's try and construct sort of innocent explanations, right? Why is there a normal person on the roof? What would they do? Well, they wouldn't run and try and drop down 10 feet.
Well, what if it was a normal person who was set up and was told to be at a certain place at a certain time and then do these certain things to draw attention away from something else? And then he ends up getting set up and they make it out like it actually was him. Think that could be something? No? Okay.
They would just go back the way they came. They would walk down the stairs if they're just a normal person going about their day and for whatever reason decided to take a brief excursion to the roof for sightseeing or something.
Yeah.
But no, this is a person who's running.
Hang right there. We got to take a quick break for Real America's Voice, and we'll be right back.
Oh, get out of here, doofuses. They don't come back. They just watch the trial. I just want to see what they're saying because they're such D-bags. Here we go. Here's some more D-bag stuff.
I think from Kathy Nestor, the defense attorney's cross-examination of that witness, she's obviously trying to poke holes in some of the ring camera footage, which I think is fairly flimsy. I mean, trying to remember what cars drove in front of a person's house would be extremely difficult. And then you actually do have the ring footage, which is what it is, right? So I don't know.
And then they forget to say that the driver of the vehicle was bald and there was multiple people in the car. They forget he completely forgot that part when he was describing the vehicle, right? He forgot to say like there was a bald guy in there, which could very well have been Blake Neff for that matter, because he's bald, right? Could have been Blake Neff and this sausage fest here with Andrew and whoever that other guy was, that multiple people, 3 others in the car. Yeah, I mean, it could be many, many things. Many, many people. I don't think Tyler is bald.
I don't know what they would make of that or if that would be compelling evidence to a judge or jury. Then you see the cross-examination by the state going back kind of and reacting to some of Kathy Nestor's cross. And it felt like he did a fairly thorough job of kind of plugging in all those holes. They keep talking about this bullet casing not being found on the roof. That has been sort of dealt with as well, that if you have a bolt action rifle and you only fire one shot, it doesn't eject the casing that was found later. So anyways, lots of interesting back and forth. We're going to take a quick break here where I guess we're going to keep going.
Blake is such a dork. I cannot with this dork. I really can't. I can't. Look how stupid he looks. He's just so ridiculous. Every time he laughs, I cringe. I just like, he's like, and he always bounces. He goes, I wonder what he's sitting on, that he has to bounce so much in his chair.
No break. All right, that's good. We prefer it that way. I would say, I think we got it.
Look at his arms too. Like, I don't think I've seen a man with arms this skinny in a really long time. Like maybe a grandfather or like a 7-year-old. Know what I'm saying? No muscles. No muscles there at all. Every single person in chat could beat him in an arm wrestling match. No muscles at all. No hair, no muscles. What a life, huh? What a life. No wonder he picks on ladies. No wonder he picks on, you know, women and minority women. Can't pick on men.
Mixed up there whether we were in break already. But
Yeah.
no, so
Oh, I see.
the
Yeah.
most important thing, I mean, we got at that a little bit, is that they basically asked them, did you have any suspects before Tyler Robinson turned?
Yeah, look at that. No, just no muscles. No chest muscles. Look, his cup's on the floor. He must get down on the floor to drink it, lick out of it. Down there in the corner. That's funny.
himself in.
Yeah, that's a
And
very good point.
I think they might be setting up as in, you didn't really deduce that it was Tyler Robinson until this happened. But the flip side of this is that's absolutely devastating to people who are claiming, oh, he didn't turn himself in, the weirder stuff that he was coerced into doing this.
It's so weird that he would have been like coerced into doing this. It's like the weirder stuff. Coerced. He was coerced. I just can't. Yeah, just strong wrists and fingers. Kate, you're 100% right. He looks like he's got, I mean, he's always doing these type of motions when he's talking. He really likes to use his hands. You know what I mean? He likes to see his boyfriends, I guess you'd call them. Boyfriend number 1, boyfriend number 2. I just assume he likes to see them multiple times throughout the day. Then he's bouncing in his chair all day. It's just very strange and off-putting. But I do like to hear their stupid ass theories.
Yeah, and that was actually kind of I think a moment that you could skip over and kind of not hear it, but the defense themselves is admitting that Tyler Robinson turned himself in. So, you know, what would compel him to do that, besides being guilty of the crime of the
Perhaps, you know, he heard the police officers talking about how somewhere out there was a note written where it said like he was going to take his own life. And he thought, Jesus, I never said anything like that. Maybe I don't want to get unalived. I should probably go turn myself in since they are. Also, you know, when you find out that the police are looking for you, I'm sure like many of us, probably 99% of us would be like, what? The police are out looking for me. There's pictures of me online. They're looking for me. I better go turn myself in and see what this is about. So there's 2 reasons right there. And that's just like off the top of my head. And I'm not even like a genius or anything. I really am far from a genius, but I'm a whole hell of a lot smarter than Andrew Colvett, it seems.
alleged crime here.
Because he can't figure it out.
I don't know what
like,
you could surmise
I
from
just
that.
don't know.
There was also this.
I just don't know.
There was also this interesting moment where
I just don't know.
talking about like some of the camera footage that there were multiple angles or something. SOT 12.
I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
Nope. Hang on. We are back.
Yes, Your Honor.
We are
I intend
back.
to call Jennifer Falmolina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Engelhardt from Turning Point USA.
All right.
And Yeah, again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102.
Oh, interesting.
There are also, there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak, as you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think, I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the third person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA, within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the second paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, or that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Englehart's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhart says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Englehart's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Englehart's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information,
I'm
that
not
is
sure
the
if he's
document which
defense or
lays
prosecution.
out,
I don't know.
the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged.
I'm gonna mute this a second because he's just trying to explain a document that he wants to like do something with, but he's not sure if it should be shown to the public yet again. Yeah, we don't know if this is defense or prosecution. And I know what you mean, Bootsy. I totally get what you're saying. When you turn the screen and it makes it full screen on this bigger version, you have to like turn it back to the small version to type. It's kind of weird when you're on your phone. So I totally get why you'd be on the vertical. I hope you can see the little mini chat that I put at the bottom of the screen there. I'm hoping that helps you to see what the chat is talking about. I don't know. I can make it a little taller maybe. Help you see like what all the chat is, because there's like 2 chats going on, but if you look on the screen there, you can see just the one version of it and be able to chat with people in that chat. But I know what you're saying. It's yeah, it's like weird to turn the phone and get to the right place to chat. When I forgot about that when it's on full screen. That is annoying. Are they still talking about this stupid document?
Belief or perception regarding Mr. Kirk's political expression.
Ooh, I think this is something, you know, about Philadelphia.
Talking about when, or whose state of mind is the statute talking about? And what
Maybe that's the maybe that's some text message or something that Charlie's talking about. He's afraid of Philadelphia. Oh, that could be it. I don't know what the hell he wants to show, but they're like, no, you can't have the you can't let the public see this. So now they got to talk about it in code so the public doesn't know what he's saying.
that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R.
What?
I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K.
20. Maybe you can read these nuts. That's about it.
Subsection,
honestly.
I'm sorry, the 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant.
True that.
And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here in this proceeding what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks and again, I say this with all due respect to Mr. Engelhardt, who I've never met, the book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence.
At this point, I just want the judge to read it, because it would have been much faster than this, to be honest with you. Just read it. Who cares at this point?
Is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Engelhardt's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here.
Okay, he did say
When I say important,
so
I'm
she
saying
might
it's
be
not
there.
relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue, we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Oh my goodness, now the next one has to come up. Cry about it. Here we go.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information.
He was.
The statement
Defense,
clarifies what Turning Point USA, what
Prosecution.
Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading.
Yeah, what a dick. He literally just said he doesn't want the judge to hear all this political and religious crap. And he was very careful in selecting all of his words so that it wouldn't influence the judge's mind at all. Now, the prosecution comes up and literally says everything that's in the note to the judge. That's such a dick move.
From the actual 1102, because it's not admitted into evidence. I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor is.
He literally just said what was contained in the exhibit without saying what was contained in the exhibit.
Explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Oh.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. not necessary for Mr. McBride to read aloud in open court an exhibit which court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right, thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits.
Well, then you're not a good attorney.
If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And
What?
I
Is
think
this
my
little
job-
dickhead really complaining about having to do his fucking job? Is this guy for real? Then he sucks as an attorney.
Job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at
I hope
this,
he blocks
typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand
Exactly.
and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, in talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly, saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride in regards to your response, the rebuttal to the argument by Mr. Novak. What is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the...
Really? Because you just said you had to close the hearing because you couldn't describe it without it, talking all the points. This dude is such a wanker. Can you believe this? He literally was just threatening, like, we're going to have to close the hearing and then go read it because I can't do my job without so. And now he's saying, well, do you want to close it? He's like, no, I don't think we could.
admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty. I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing.
No,
that
you
the
just
argument can
asked
be
for
made
it.
without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done.
And is this guy serious right now? Did we not just hear him? Am I going crazy? Or did we not just hear him whine like a bitch and say, we have to close this hearing if I can't talk about this? And now he's like, no, he's the one who said it. The judge's face is priceless, indeed. This guy is trying to gaslight the judge right now is what he's trying to do.
That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right.
Idiot.
Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
Wow.
No, I don't think so.
All right.
Not such a good lawyer, is he? Not such a good lawyer at all. Now, the other guy might have taken 20 minutes, but he was able to do it just fine.
Your Honor, if you're going to make that closure ruling, I'd like to be heard before you do.
All right, I'll hear from you as well. If you would like to come forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And that's been, we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it, Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, a closed session or a sidebar or however, you have also done it in chambers, I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar, and I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right, thank you.
He told him.
Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility, that's all.
All right. All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder, and whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information, going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Most political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families.
Just
and
read the
gender
fucking
identity.
letter at this point. I mean, you're
And
saying everything in the letter.
That information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses, that talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that we'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point, and it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. That's. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it. You said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling?
Did you see that look he gave him when he walked past?
In-depth
He was
argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
Why?
Result.
How does this guy know the defendant's state
All
of
right,
mind?
in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The
He's gonna
purpose
let
is to
it through.
determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence.
I knew he would. I knew he would.
And at
He's gonna
such
let some
point
random
when it becomes
fucktard
relevant,
tell him what's going
based
on.
off what
Oh my God, don't
Mr.
move to
Novak
Utah,
has
people.
talked about.
Do not.
About Mr. Robinson's state of mind about Mr. Kirk's political
Unbelievable.
beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again, and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed.
Unbelievable.
Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's go.
No, everybody looks like they want to punch you in the face because that was just the most retarded thing I've heard all day. I can't with this. He's literally letting some random person who doesn't even know Tyler Robinson weigh in on Tyler Robinson's state of mind. I mean, what? Seriously? He's like, no, we're going to listen. I'm going to take that evidence. But like Barron said, they could, because they allow, what is that, hearsay, they could take anybody. You could come up and say, I heard, Tyler Robinson thinks this, and he can take that into account, which is absolutely just insane. Don't move to Utah. Do not do it, people. Don't ever even go there. Don't even pass through. If you have to go somewhere, don't even lay over in Utah. Stay the hell away from Utah. Yeah, and Charlie's state of mind. Unbelievable. Unbelievable. I just can't believe these guys. I'm in just like complete shock right now. Unbelievable. What are these guys doing over here? Let's hear what they're saying.
So people coming in know that we're on a lunch break. All right, there we go. Pull this up here.
Was there information about the ammunition left in the rifle? Was there a spent shell casing? Was it fully loaded with no spent rounds, residue on the hands?
They're still beating us over here, guys.
Anything with the firearm yet?
They're still beating us. They got 113 people. We have only got 95. Let's get those likes up. Come on. We've got to beat the sausage fest at some point today. We have to do it. We need more people. If you're just tuning in, please hit that like button. Please subscribe. We are trying to just be the winner today. Nobody really wants to watch this court hearing, but we're broadcasting it anyways for you guys, that the small amount of you guys that do want to watch it. And, this is the best channel to watch it on because we're fun. We're amazing. Our chat's like brilliant. We have people from all over the world. And I'm cuter than every single one of these guys. So tune in over here. Come over to my live stream. But let's hear what they're saying, because they probably have some good points. These guys are really, really smart, and they know a lot about what's going on in court.
Could be, but I don't know. I don't think
And we can just spy on their stream.
How long is that rifle? Like 42, 43 inches?
in between 44 or 42 and 44 inches usually.
Okay.
But
Did you take off the
you know,
stock though?
Yeah, that's what I was just going to say. But had he taken the stock off? I think
Yeah.
Mauser breaks down into two separate pieces. So
You know
you didn't
what?
take the
I asked Grok early on in this case. I asked Grok about, I told him to analyze the stairwell pictures of supposedly Tyler Robinson. Okay. I said, analyze those pictures based on his height and weight and size and what he's wearing and the backpack he has on his back. Can he be like carting around this Mauser firearm that they were claiming that he had on it, right? They claimed that he had this on him at some point walking up the stairs to get to the roof. And Grok said no, it was impossible based on his height, his weight, the size of the backpack. And he determined all that, you know, from his shoe size and all that stuff. And he said there's nowhere in the jeans that he could have placed this firearm. It could not have fit in the backpack, even taken apart. That was Grok. Grok said it. I think Grok knows measurements and things like that way better than we do. And he said, no, he couldn't have been carrying it. He couldn't have had that on him. So how in the world did he get up onto the roof without it and, you know, fire it and unalive somebody with it if he didn't even have it on him when he was headed up to the roof? That is a big question that I have. And I don't understand why. I believe it when it comes to things like measuring a human being and looking at his skin tight jeans and him saying that the size of the backpack, you know, because he knows the relative size of the backpack that he had on, the brand and everything. He measured the size of the backpack. He measured the size of the gun or the firearm and said that he couldn't have fit it, you know? So that's what I believe. That's why I believe AI in that situation, because I can't measure that up and I can't estimate the size of somebody and all that stuff. But it's just like, even looking at it, you can tell there's really nowhere it could have fit. And even taken apart, I wanted to know, taken apart, could it have fit in that backpack? And even the size and shape of the backpack did not allow room for that thing to fit in it. And so I definitely believed at that time, just because, you know, Grok's a genius when it comes to that kind of thing. And I believed him. And also, why was he limping at one point and then all of a sudden walking just fine? And why did he have the thing? Then supposedly they said at one point he took it apart, right? Then he climbed down off the roof and then he hid it in the woods, fully assembled again. So I found that kind of strange also. I just think it's very strange, the whole handling of the firearm altogether. You know what I mean? It just seems very strange to me, very odd to me. And I just, I don't know. Yeah, see, we got somebody in Germany. All right, all right. Nice. Grok needs to take over the judge. AI is dumb and way biased. Yeah, AI is usually biased towards the people at Turning Point USA and all their stupidity. When I ask him to help me with things, he always takes on the point of these, like Andrew and Blake being super smart. It's hilarious. Remember, for 3 months, Painful Truth says allegedly F you, allegedly F you, F you, F you, F you, F you. I know, I love my stickers. Thank you, Painful Truth. Oh, thank you for the super sticker. Thank you so very much. And thank you for being a member for 3 months. I appreciate that. People need to look up what the World War II 30-06 Mauser looks like. Yeah. Yeah, I just found it strange that it would not fit in the backpack. And he's limping around for some reason. They're saying because it was down his pants, but his pants in those pictures were skin tight. And so I don't understand, you know, how he got up there without us seeing the imprint of that thing in his pants. But then again, he didn't have a limp at some point. So then he did have a limp, then he didn't have a limp, but he didn't have the thing on him because it couldn't fit anywhere. Then he gets up on the roof, he lays down and takes this He does the big bang, and what they say 30 seconds, he runs up, lays down, does the big bang, disassembles his thing, does something with it, jumps off the roof, runs into the woods, assembles it again, wraps it up in a towel, and like, it's the dumbest shit ever. I just can't. Thank you for another super sticker, Painful Truth. Thank you, thank you, thank you. I appreciate that so very much. Brian said this is like a joke. Yeah, it looks nothing like the stock rifle they keep showing us. Wow, I didn't realize that. I didn't realize it didn't even look like the stock rifle. That's insane. Yeah, but the stock rifle that the grandfather identified, right? Or wasn't it the dad or the grandfather identified the stock rifle? It was like, that's mine. Like, come on. Another pic showed his leg bent. Yeah, it's like, how? I thought he had it down his pants. And then you look at his pants and they're skin tight. Like, come on. Us, especially as ladies, we've worn skin tight pants and you can't really shove things down there without seeing an imprint. I mean, we wear skin tight pants and worry if our cellulite's going to show. And you're telling me he had a whole rifle down there? Get the hell on out of here. And nobody saw it? Come on, son. Come on, son. And then they showed the picture. I think they showed a picture of like Lance Twiggs in an airport or something, and he had the same jeans on that was in the picture. Like, this is just all so crazy to me. And then we've got the judge sitting there saying like, yeah, we're gonna admit all this in here. Yeah, changed his clothes a bunch of times. Like, yeah, he changed his clothes, he disassembled, reassembled, disassembled, then reassembled, was limping, then he wasn't limping, then didn't he have like white shoes, then gray shoes, then like, I mean, the whole thing is just completely out of this world crazy to me, and I just get the biggest kick out of it. Like, I just can't. Yeah, see, yeah, they seem to have like a prejudice towards Turning Point USA. The narrative that the Fed slop is given, like, that's why I was really shocked, Kate, when Grok agreed with me that there's no way that thing could have fit, and he didn't have it on him. I was like, does this man have this particular weapon on him in anywhere, in the backpack, in his pockets, anywhere? Is there a place where it could fit? And I was shocked when Grok came back and said no, because they're very biased towards all this whole Fed slot bullshit. It really is. And yeah, I'm just like so sick of this judge allowing every little detail in here, every little hearsay. I mean, I get hearsay's admissible, so I guess he's just going to take every piece of hearsay and then determine like, well, does everybody think it happened? And if everybody else thinks it, I'm going to think it. And then we're going to put him on trial for his life. I think it's just really outrageous when this young man's fighting for his life. I've yet to see one piece of actual, for real, legit evidence pointing to this kid, especially when we just found out that there was a whole other, you know what, bullet laying on the ground. There was a actual holster laying on the ground from a whole other weapon. I mean, this shit's absolutely crazy. Then we find out, yeah, they did see Tyler's vehicle rolling around town, but there was a bald guy driving and 3 other people in the car. Like, what? Wait, what? I thought it was Tyler driving around. They literally made it seem like Tyler was in that car driving around. They never once asked him to identify the driver, tell us what he looked like. They just made sure to remember that? The prosecution was like, what? Well, what did the car look like? How did you notice it was the car? How did you know that was the right vehicle? They never once said, like, did you see who was driving? They conveniently left all that out until the defense comes up and is like, well, who's in the car? And they're like, oh yeah, some bald guy and 3 other people. Like, wait, what? We found out a lot of information from this one today. Even though it's boring as hell, we really have found out a great deal of information that we just really didn't know was happening before. I mean, we really didn't realize there was a holster that they just left unattended on the ground. Nobody really worried about that. Now we've got a bullet on a whole other rooftop, and they're claiming that it was one of the officer's bullets when he cleared his weapon, which, you know, he was trying to then put the bullet back into the, whatever you call it, there's a word for it, the whatever. He was going to put the bullet back in, but you don't do that until you get back to your car. So why would he have tried to do that on the roof? I don't know. Do they have documentation of this missing bullet? Does anybody anything? He didn't even know the caliber of the bullet. So how do you know it belonged to one of the police officers? They were like, well, what's the caliber of the round that you found? And he's like, oh, I don't recall. Oh, but you definitely recall it belonged to a police officer. Well, how do you know if you don't even know what caliber bullet it was? It just seems like there's a lot of stuff we did not know about. And so, yes, this was really boring and we're bored out of our damn mind. Yes, we found out some really good tea. We did find out some really good tea. They had the dogs sniffing around, except they don't really know if they sniffed around down by where the, crime scene actually was. I can't wait until they get to start asking them, like, who decided to pave over the crime scene? Why didn't the dogs sniff around down there? I mean, there's all kind of stuff. I can't wait until they get into that. Like, I just really can't wait. Yeah, they matched the wheels, not the license plate. Bald guy driving. That's what I said. What was Blake Neff doing down there? I really don't know. I don't know why Blake is cruising around down that area. I really don't. Just insane information we found out. Yeah, oh yeah, then another one in a bag. Yeah, they found another one in a bag. So there was all kind of pew-pews at that scene that day. There was all kind of pew-pews. There was bullets, there was pew-pews, there was holsters. But you know what? The sound. It was the sound that they heard. And the thing is, if you found Tyler Robinson's rifle in the woods, but you found another pew-pew in a bag at the scene of the crime, why was that one not treated just like the one they found in the woods a little ways away from the university? You think they would treat the one found on the scene with the same amount of suspicion and do the same amount of testing, all that. Why did they not do the same thing with the one they found at the scene? And why would you assume that the one at the scene was not what did it, right? It was not what did it. We're talking about a huge, powerful rifle that was found, I'm going to say like a mile away. I don't know how far in the woods, even though there was no exit wound and things like that. We're going to assume it was the super powerful rifle just because people heard us. The one guy heard the sound. And when he saw the holster, he referred back to the sound he heard 10 minutes beforehand and was like, oh yeah, that wasn't a hand one. That was a rifle. My bad. This is insane and absurd. And I cannot believe that they ignored so much evidence and treated, one of these firearms like it was absolutely 100% need to be tested in every way, fingerprinted the whole 9 yards, but the one found in a bag on the scene of the crime, they just disregarded that. They cleared it. It was dropped by a Fed. Yeah, it was dropped by a Fed. They cleared that just like they cleared the bullet. They cleared all that stuff immediately. They were like, oh yeah, this one here didn't do it. Because I heard it and I heard the sound and I'm thought maybe it was that. So yeah, that wasn't it. And yeah, most of us just want the truth to come out. We just want to know the truth of what actually happened. Valhalla said, hell no, that would never happen. What, the sound you mean, Kate? Yeah, our discernment tells us something isn't right. Exactly. Some of us do have discernment, because anyone, yeah, that's true. That's true, Kate. He made a good point. Yeah, because anyone can pick that up and commit a crime with it. Exactly. Oh, Elmer, they found the one in the woods. They scoured the woods with their manpower. All the police officers, law enforcement officials that were on the scene that day scoured the woods and they didn't really find anything at all. And then a couple of people came up with a dog and the dogs scoured the woods and didn't find anything. And then 2 human beings came up, 2 or 3 new human being police officers came on the scene and they immediately found it, even though the dogs couldn't find it. Yeah, so the people actually found it after the dogs cleared the area and found nothing. Yeah, the mountain of evidence is an anthill. Yeah, brand new ones came and found it. Brand new ones came and found it. Pretty wild to me. Pretty wild, the stuff that they're trying to force on us and make us try to believe, like, you know, we're a bunch of morons.
Freewater, Oregon.
Hell yeah.
That's in your neck of the woods. Carrie HS, looks like Canada. That first witness yesterday, Bagley. Yep. Remember the UVU video shortly after shot bang of the man, black shirt, light ball cap, put on a sheriff's badge. He noticed he was being filmed and then he removed the badge. Yeah,
I do
that's what
remember
think.
that.
Yep.
I do remember that. Yep.
Yeah, I got that footage.
Well, now we know there was people running around in plain clothes with guns and badges, according
Guns and badges. Yep.
because he randomly met a guy. He had no idea who he was with a badge. So
Yeah, that's
But he trusted him
and trusted him enough to go try to clear the area. Yeah.
with guns out. Yeah.
Seems weird. Not something I'd do, but
Yeah, and then they get to the roof, and where did the guy go when they got to the roof? Because the story with him clearing the area with the guy did not include him being on the roof with the guy. All of a sudden, the guy's not with him, and he's on the roof alone. And nobody thought to ask, well, where did your partner go?
I-5 corridor down center with Portland and Eugene. That's woo.
Kathy Winesickle, thick is good. Isn't that how we like our milkshakes?
Yeah, we like our milkshakes. I don't know what that's about. But yeah. Yeah, I don't know if they were FBI or I'm not sure if they were FBI or just random law enforcement officers. As you can see, we had the S's and Sam. SBI was on the scene. I never heard of the SBI. I never heard of the SBI, but evidently, you know, he was around. I don't know if he was around later. I don't think he was on the scene, right? He was just around later, helping with the investigation for some like reason. I am not really sure why. Let's see if we can find a Paramount Testicle. I thought he was watching too. Oh, I'd love to hear what he had to say about this. Shiz. No, that's his website. I ain't trying to go to his website. No. I don't want to see him on YouTube. I'm trying to buy nothing off of him.
Like you're a born politician, man. I want to see you. I don't know.
I will
Come-
never run for office. I will never run for office.
Ass
Maybe like
kissing.
school board of my city. But thanks, guys. I appreciate you.
Yep, we appreciate you, man. Have a great day.
You too. Bye.
Thanks. All right, folks. I am gonna go get some lunch real quick.
Wuss. What a wuss. What a wuss. He ain't in it to win it. Wussy. You're gonna go get some lunch. Who's that lady? She's out too. They're piecing out over there.
Let me just make sure that I've caught up on all the super chats real quick. I threw this one up there earlier, but I think it's worth repeating.
Oh, Jen's resting. Oh no.
Yep.
Somebody should join and come up here and chat with me. We can play a game in the chat.
You know what? I'll put a guest link down there. If somebody wants to jump on, even audio only.
I should jump on there, guys. I should jump on that one though. I wish I could do it from here. I don't think I can because I'm already live, but that would be hilarious. Damn. He's putting a join link up. Man, that would have been so good too. There's no way I can do it from here. I think I'd have to join. I would have to join on his StreamYard to still have it play on my live. Man, that would have been funny. That would have been funny.
Especially once it gets to the trial. When we have additional investigators come on there, people that were probably
When it gets to the trial, you're just assuming it's going to get to the trial already. You're assuming. Rude.
different picture altogether. Kamala School of Word Salad, Kamala, whatever her name is. Politics is downstream of faith. Couldn't agree more. It's really difficult to separate those two. And why does it matter? Like the argument is that basically because of bigotry, whether it's political or and that's essentially where that enhancement is coming from, right? So whether it's politics or faith, I don't know that that really matters. It may not apply to politics. That may be where they're going with that. I have to look at that. I'm not a lawyer. Don't pretend to be
Oh
one.
wait, what? Sorry,
Why
that
are
was
frogs
so
good at
boring.
baseball? They know how to catch flies.
Sorry, that was so boring. Like, my bad. Yeah, that's funny. Let's go back to these guys. They're way better.
Sammy Cross, thanks for covering this. I'm watching from my bed with while in a huge flare up for my illness from Lancashire, UK. I'm sorry to hear that.
I hope you do
Hope
better.
you distract from the pain. Well, I'm glad we can give you a little bit of freedom from it. That's terrible.
No, these guys are just going through super chats. They're not really talking about the case, and Gary's just giving his advice on stuff. Yeah, he's going over his super chats too. They're not really talking about the case. I was hoping, wait, what about what their guys' names that we were looking at before? Oh yeah, the Charlie Kirk show. Where's those idiots? I turned them off. They're probably not even still watching, probably. I doubt it. But maybe they are. You just never know. Oh, they're still alive. Okay, they're still alive. Oh, they're on a lunch break too. Look at all these wussies, guys. I mean, they can't even hang. Bro, they can't even hang like we do. We don't go on no lunch break over here. Come on, son. You just leave your audience. They're just like, peace out. Like, I got a million things I could be doing. I ain't leaving. These guys are all wussies, man. Well, these guys didn't leave either. Nate and them didn't leave either. They're still on point. But Paramount Tactical left and yeah, wussies. Snooze fest, please don't do it again. I thought we could pick on him a little bit, but there wasn't really nothing to say. It got really boring really quick and I fell asleep. That's my bad. I tried to stay awake for it, but it was just like, I couldn't even make fun of them because it was like so boring. You know what I mean? I wonder, let's see. I wonder what the Daily Mail is saying. Yeah, they got cyberbullying to do. Let's see. Oh, wait, let me look from my other internet because I can't stand getting all them ads on my computer. Daily Mail usually reports something stupid. It does have something stupid to say. Let's see. Let's see what they say today. Let's see what they say today. The judge was visibly shaking during a tense moment. We saw that yesterday watching previously unseen footage of Charlie Kirk's unaliving during the hearing. We saw that. He visibly winced watching a previously unseen footage of Charlie Kirk's unaliving as his alleged assassin, Taylor Robinson, had the first day of his preliminary hearing. What? You know what? I tried to find that article. They changed it. We read this article yesterday from the Daily Mail live, and we made fun of it because they had a couple of inaccuracies. They kept saying that Erika Kirk was sitting a few rows back from her in-laws, and then they said, but she leaned on her mother-in-law's shoulder when she was crying. But I didn't understand how they did that since they were 4 or 5 rows away. Right? We read that right here on the live. And I did download it, thankfully. So I have the article there. But do you think I could find that article again? It's gone. And now they're saying, in its place, they're saying that Erika, dressed in all black, faced her husband's alleged unaliver for the first time. Let's see. Robinson was at one point seen laughing as the Kirk widow, Erika, wept just feet away. Like, do you believe this? They didn't say that yesterday. Didn't have nothing to say like that yesterday at all. But now and we read that article after Erika left the courtroom, didn't we? Because she was already gone and they didn't report this. I think we read that after she left the courtroom and they did not report that Robinson was laughing at her. That is such a lie. We had our eye on Robinson all day. He was on camera all day and we did not see him laughing at her. This is such bullshit. Did you guys in chat ever see him laughing at any point yesterday through that whole trial? Was he laughing at any point? Because I didn't see that. But they're reporting that yes, he wept as Erika was feet away. She was accompanied by her rarely seen in-laws, Robert and Catherine Kirk. However, we did watch them go into the front of the courthouse. Stacy Sheridan tried to interact with the father. He ignored her. And then we saw Erika going in through the side with her clone bodyguards. So they did not go in together. And the Daily Mail reported they did not sit together. They were rows apart. And now all of a sudden the story changes. She was accompanied by them. Tyler Robinson laughed at her as she was crying. This is bullshit. The parents were spotted leaving the first day of their son's preliminary hearing. They forgot to mention Erika left as well. Remember, she left as well, but they didn't report that. The parents of Robinson were spotted leaving. Is this such bullshit or what? This is unbelievable. There's Erika leaving. She abruptly left the courtroom during the police testimony. That's right. She definitely did. Amber Jones and Matt Robinson were stone-faced and did not speak to reporters as they left the courtroom. Trump Jr. and his wife, Bettina Anderson Trump, showed up to support the sobbing widow. Bitch, when was she sobbing? Because I heard no sobbing. I'm pretty sure we would have heard her sobbing had she been sobbing. Maybe she was crying, but I didn't hear any sobbing, right? Yeah, he was taking lots of notes or drawing. Didn't see any laughing. They were all in the front row, Brandy said, probably designated seating or reserved. Yeah, well, I don't know why the article said twice that they were rows apart from her. Maybe they meant seats apart. I don't know. He turned himself in, but he also sent a text message confession to his transgender partner. Again, they did mention we talked about that, the transgenderness of it all. Like, we don't care about his penis or vagina or whatever it is he has downtown. Literally don't care. He's still not entered a plea, I guess. But I mean, I don't know if I even believe this, because I don't, they say some random things that don't seem to be true. In some cases, Judge Graff has decided videos can be shown and they can be shown on the live stream of the hearing. In other cases, he's allowing it to be introduced but not shown. The parents of Charlie Kirk's. Okay, so this is Tyler Robinson's parents right here. Tyler's defense teams argued that some of the videos may have been altered with clips taken from longer videos. Some evidence may violate his due process rights, in part because the people who made or edited the video aren't in court to testify. The judge is also considering whether some of the video or written evidence is so prejudicial that it would make it hard to find impartial jurors. And if the case goes to trial, Kirk's parents and his widow all left the courtroom shortly after UVU officer Chris Bagley began testifying. And did they ever come back? Did they ever come back? I don't know. There's Charlie's parents. Erika was accompanied by Charlie's parents, but they just don't show them together at all. I just get a kick out of this. He saw a disturbance in the gravel that looked like a sniper pad. I love that one. That one was probably the funniest of all. What size is this gravel? Unless this is like tiny pea-sized gravel, I doubt you saw an imprint of anything. Gravel barely moves when you step on it, let alone spreading out your weight over top of the gravel. It would have to be very small gravel. They should actually bring in an expert scientist to determine whether this could even be true based on the size of the gravel, because I guarantee you there's some type of scientific evidence that could either prove or disprove this 100%. When you lay down, you distribute your body weight, and it's much less per square inch or square feet than if you're just standing on it. And so if he's lying on top of the gravel, depending on what, you know, his body weight is, how much of his body weight is pushing on that gravel to displace these pieces of gravel, it would depend on the size of the gravel. Are they those giant rocky gravel type? Like, are they big rocks, or are they tiny little peas? Like, what type of gravel was it? This is all things they should be asking. I guess maybe then they'll ask that in the trial, maybe. But they didn't claim to see any footprints in the gravel, I didn't think. So how do you lay down in the gravel where you have much less body weight per square foot and there's an imprint, but you walking where there is much more weight per square foot and there's no imprints? I'm kind of confused by that. So I would love to see, if this does go to trial, I would love to see them bring in an expert for that. And I think they could totally get that thrown out. Erika leaned her head on a friend for comfort as the testimony was delivered. Who was the friend? Was it a boy? Was it a girl? She was clutching, Catherine Kirk was clutching a pocket-sized packet of tissues. Robinson looked at the exhibits on the monitor and took notes. Nestor, during her cross-examination, questioned him about the report he wrote after it, including his observation about finding an empty holster on the ground. I'm surprised they mentioned the holster in this. He acknowledged that he never took custody of the holster and he doesn't know if it was even fingerprinted. I'm taking a screenshot of that because that's hilarious. Hilarious. She asked Bagley if he ever attended a meeting to discuss how officers would keep people safe on the day. He did not. He wasn't given any tactical or operational plans before the event either. Another good point. There were 6 officers working for thousands of people that attended the event. There were no metal detectors being used. There were no law enforcement officials on the roof, stairway, or walkway. Unreal. Okay, so the SBI is a place that helps other law enforcement agencies process crime scenes and investigate after serious incidents. I didn't know that was what they did. Did you guys realize that? I did not. Unbelievable. Yeah, have you seen gravel on a rooftop? It's not like walking on the beach. Where are we at for merch sales? Yeah, I know we didn't get to hear that. We didn't get to hear where they're at for merch sales today. Probably somewhere around, 82 million. You know what I mean? It's probably somewhere around 82 million. Usually there's tar under the gravel, so there's not likely to be an imprint. I really wish that they would send an investigator, the defense would send an investigator up to check into that, because I find that to be hilarious. And you know what? Gary from Paramount Tactical, he has drone footage. Okay, hang on a minute. Let's see. Hold on. And Gary and Bays did that live stream, and Gary showed, dang it, let me just go to his channel and see, because he showed that videos. Let's see, videos, or no, it would be under live streams. There it is, Gary and Bays. All right, let me pull this up for you guys instead. Let's look at this because let's see. Where's it at? Camera, Candace Owens. There it is. Okay, and let's see. Okay, so here's the stream, and at some point, Gary shows the drone footage. Okay, so here is the gravel. It looks like it could be the small. I wish we could be closer to it, but look, there's like an indent there. You can see like an indent over here on the side. I don't know. Can you guys see my mouse moving? Let's see. I'm gonna get bigger. So there's like a little bit of an indent here, but they're saying here is where he laid, I guess, where the circle is. But the indent looks to me like it's on the corner there. Okay, so that gravel is, I don't know, that gravel looks pretty big to me. I mean, I do see indents on the roof. I do see indents in that gravel. Hold on, let me make it super big and take this down. But do you see how on the left side there, it looks like there's a big indentation, but the circle is showing, I think the circle is supposed to be where he was laying. So I don't understand why the indent is on the other side. Kate says, I just know SBI is the website I go to check if I have warrants and now to find out about expunging my record. All right, so the SBI has other jobs as well. Good to know. Yeah, this gravel looks kind of big to me. I don't know. I would say it's probably medium sized. I wish we could have got a close up of it though. Let's see. Yeah, that seems to be. I thought he flew this up to the roof. Here's another section where it shows the roof. I'm sorry, I see tons of indents all over the place. How do you get that this is possibly where somebody laid? I don't see any. Yeah, they're saying that's where he laid, and I don't see it. Sorry. I do see an indent here, but I see an indent up here. I see an indent on the side. Like, get on straight on out of here, trying to tell me that he laid in that spot where there's the least bit of an indent. You know what I mean? Thank you, Bittersweet. I appreciate that. We are a lot of fun over here. We are a lot of fun. You guys make it fun. You're the ones who make it fun, actually, so I can't even hardly take credit. 5:30 a.m. Oh my gosh, it is 3:23 p.m. where I'm at. Yeah, the left side looks more plausible. That's what I think too. That's the corner of the building looks like it's in the way from this point. I mean, I guess he could have, but in the 30 seconds they're saying he I guess ran over the right here. He jumped down, got in the prone position. He, fired the round, which like from that far away with grandpa's rifle. Like, I don't believe that. I don't believe he could have made that shot. And plus you're under all that pressure. Your heart's pounding. Unless you are a trained sniper, I don't see you making this shot. This is like 1 in a million. I mean, this is like winning the lottery. The odds are probably the same as winning the lottery. And you're telling me this kid laid down and within 30 seconds, laid down, pulled off the, big bang, disassembled, stuck the thing in his bag, ran over, jumped off the roof, and all that stuff in 30 seconds. I don't know. I don't know about that. And that indent, like, to me, it looks like he was on the corner. That indent on the corner looks like that's what there is, you know. I don't know if they took DNA from there. I really don't know. I know. I know. That's so true. It is. It's sucking my energy right out. But I'll tell you what, I'm still going. I'm still going. And Gary and all them guys are taking a lunch break. They're like, we got to take a break too. Like, yeah, wussies. Wussies. Bunch of wussies. Let's see. Oh shit. Hold on. There's a high-rise building on the verge of collapse. Wait a second. What is that? Let's see if I can pull it up. Oh shit. Let me see if I can get this link. Let's see. Can I get this somehow? Of course. Oh wait. Share. Copy. Hold on. Paste. Something's going on in New York City, guys, right this moment. We've got a live high-rise building feared to be on the verge of collapse right at this moment. We're waiting for this to begin. Let's see. Let's go back and see what they said about this. I guess this building is going to fall over. In New York City, that's going to be crazy. I wish they would start already. What's the deal? Let me just look it up on the news instead of this. Let's see. There's got to be something here. Oh, wow. This is... Okay, I agree. So... Are you guys, let me make sure you guys are seeing this. Okay. So real quick, just a live update. There's a Manhattan high-rise unstable after columns buckle. It's an extremely dangerous situation. The Midtown building, the former headquarters for Pfizer, is being converted into apartments and it's about to collapse. An under construction Midtown Manhattan building that was evacuated after structural columns buckled remains unstable. New York City Mayor Mandami said. He described the situation as extremely serious and said crews have witnessed additional movement since arriving on the scene. The fire official said there's a concern about the possibility of a localized collapse, but added that the building is constructed in such a way that a total collapse is not possible. So there's no injuries or anything. This is on East 42nd Street, the former headquarters for Pfizer. 9 minutes ago, a city official said a team of 6 will determine whether shoring can begin on the building. 6 people will assess the structure of the 33-story high-rise. Oh my God. The building has not moved for approximately 2 hours. Can you imagine that? Can you imagine that? Like being the one that has to go in and deal with that? Oh my gosh. Like, okay, it hasn't moved for 6 hours. Let's get in and see what we can do here. I mean, what? That is wild. Oh my gosh. Yeah, they're not showing anything on the live. They're supposed to be live, but they're not. They're not actually live showing that. So yeah. Wow, that's kind of wild. All right, let's just shrink this and see. Hold on. I want to see if we can find anybody else streaming. What was Oh, Jesse on Fire's live streaming this too. Oh, he's streaming the same one we were watching. He's streaming the Sausage Fest version of this. He's streaming these guys. Yeah, so we got a high-rise building about to fall over in New York.
It's AI.
Let's see. It looks like Danks is back in.
What's up? What up? Bro, I've been watching. This shit's been crazy.
More sausage in the Sausage Fest. They're piling on the sausages now.
All right, let's see. Friends with Matt. Does Valhalla have a girlfriend? My wife is interested in him. He's leaving me anyway, so she might as well end up with someone muscular and smart.
Oh, now that is kind of funny. That is kind of funny. Yeah, so let's see. Breaking with town evacuated. Stable building. Yeah, I tried that. It isn't live. I can't find it. I want to see the building. We want to see the building fall. My husband texted me about the building, but it's not actually falling. So like, nah. Well, does he? I don't know. I
It
didn't
doesn't
hear
get
it.
much more entertaining than that. So
Waste my time. So they used DMV to verify the car looked like his registered vehicle, but did not verify the license plate in the video. They never mentioned the plates.
I believe she asked him. She said, "How do you know that's his vehicle?" And she said, "Did you do it through DMV
Partial.
records?" And I believe he said, "No, we did it based off of the shape and particularly the rims on the vehicle is how we know."
Which then he did mention also a partial match.
Partial
on the
match.
Stupid.
license,
Yeah.
yeah.
Whatever that
Stupid.
means. Couple numbers match.
Yeah. Danny V 77.7 are in, but Joe K blocked from FU on foreign leads and tips.
Joe Kent
Yeah.
blocked. Yeah, he was.
Yeah, they blocked good old Joe Kent from that one. Friend with Matt is hilarious. Oh, is he on too? Is there somebody named Matt on too? We could check him out too. I'd like to see what everybody else is saying about the trial. But everybody's just taking a break. I don't know. About the building. Honeybee said, "Damn, that's broken." Please be Trump Tower. Good one. Oh my god. Oh, that was a good one. Landlords can't rent their buildings out in Cuba. Oh, I mean New York City. Yeah, another fake planned collapse. Yeah, probably. Is that the one that little plane ran into? No, that was China. Oh, did he say partial plate, Kate? Okay, I wasn't sure if he said partial plate on that one. I thought he said they didn't, they weren't able to identify I thought they said it was the rims or something like that. They were like, it's got cool rims. You can see the rims. I just thought it was really messed up. Like, I know that's how it works, right? That's how they do that. They actually sit and they will take each witness and they'll do like, they'll sit with them prior to whatever hearings they're going to and they coach them. They're like, all right, let me, they sit down and they actually coach them on what to say and how to handle questions and things like that. That's why I honestly think that other guy was nervous because he was coached by the prosecution to answer these questions a certain way. And then when it came to the defense asking him questions, even though he's probably coached on a lot of those questions, she was keeping him off balance because she kept on switching up the questions, right? She's like talking about the car, then she's over here talking about the, other things and over here talking about something else. And she kept him kind of off balance. But I just find it so deceitful. If you really want the truth, why are you omitting these things? Like the driver was bald and there was 3 other people in the vehicle. That's a huge deal. That's a huge deal. And like I said, anybody can drive anybody's car. You know what I mean? Anybody can drive anyone's car. Even if it was his vehicle, they identified a bald guy driving. So wouldn't you, as the prosecution, be like, what? There was like a bald guy driving his car? Who's that? Who is that? Why was he driving that vehicle? Wouldn't you try to find out? Wouldn't you really want the truth if you're a prosecutor? Why in the world? That makes me so upset and angry with them, because why would you go after somebody if you know that he wasn't the one who was driving that car? Why would you continue to push this and omit, go make your way around these very important questions and not even ask, well, did you see who was driving? What did he look like? Did somebody tell you they saw, like, we're allowed hearsay, right? So did somebody tell you they saw the driver? Well, what did they say he looked like? And I just think that's so wrong to do. If you're a prosecutor, you should really want the truth. You shouldn't want to kind of guide this in the direction just to aim at the one person that, you're trying to prosecute. I mean, I get it, but I don't get it at the same time. I think it's kind of messed up. And I'm glad she asked that question and cleared that up, because we wouldn't have realized there was a bald guy driving that car. We would have never even thought that. We would have assumed, I assumed Tyler was in that car. When they showed us the footage yesterday with just the grainy ring cam footage of a vehicle driving, like stopping and then driving again, to me, I just assumed that was Tyler. I assumed that was probably Tyler in the video. You know, so if I'm assuming that, well, that just proves he was at that area at that time. It doesn't really do anything else for me, but if that's him, whatever. But I assumed it was him, even though I couldn't see him, right? Yeah. Especially when they're using her video, but omitting her testimony. It's shady. Yeah, it's very shady. And I just feel like it upsets me that you can't even trust the prosecutors who are supposed to be representing your state if you live there. You know what I mean? You can't even trust your own prosecutors because they're out here like pushing off, I guess, a narrative. He's pushing a narrative is basically what he was doing. He's pushing that narrative that Tyler was behind the wheel that night, and that's where he was doing and what he was doing. But I mean, his car could have been stolen for all we know. That could have been the people that somebody gave their own like theory or narrative that like maybe his friends, I think it was Barron. It was Barron who said, you know, picture this. You're talking to your friends, you're doing this and that. You know, they tell you to meet you at this certain place and you go to meet them, but they're not there. So they tell you to go to another place and you go to meet them and they're not there. Well, these friends, maybe these friends are who was in the vehicle driving around with him that night. Maybe they were all in the car. His whole group of friends were in the car and they were all driving around, cruising around, and they're stopping at all these places where the footage, they know that, you know, it's going to get caught on camera, but it's going to be whatever. I mean, we just don't know. We just don't know. And to think that it's like, it upsets me. It upsets me to hear that you can't even trust your own prosecutors. It's like, that's what makes the system here so corrupt. The state gains from imprisonment, fines, probation, and even treatment centers. It's a big racket. Yeah, it's like, it's a shame, especially with such a high profile case. You would think all these people would be crossing their T's and dotting their I's and trying to get it right. And I think that's another reason that we see that this is Fed slop. That's another reason why we feel that this is Fed slop, because everything we're seeing is just so ridiculous. It truly is. It's just such a sham. It's such a shame. It's like all we're seeing is trash. And then, you know, then we got to wonder like, well, why are they showing us all this? Why are they pushing this certain narrative? There's a reason they're doing that. And the reason is because, you know, that's what they want us to believe and want us to think. And they're ready to confuse everybody. And it's like, they want money. That's it. Yeah. It's just such a shit show. Yeah, why Tyler? Probably because he was doing something that he shouldn't have been, or he was tricked by his friends, you know? He seems like one of these kids that was like nerdy, hanging out on Discord, probably, you know, didn't have many friends. And these maybe a group of people targeted him because he was that personality type, that easily, you know, manipulated personality type. And we haven't heard anything from him. Who knows what he's got to say? We may never hear what he's got to say until after this is all over. If he ends up in prison, somebody goes and interviews him, or if he ends up a free man, they're going to change his name and move him somewhere. No one's ever going to see him again. So we literally may never find out. I think that's the point. I think they're going to do all this for show. I think they're going to let him off because they really don't have much evidence on him. I think he's going to get out of this somehow. Even if they go through with a whole entire trial, it's going to go sideways. He's going to get out of it, because if they imprison him, there's a chance for him to tell his side of the story, unless, you know, something happens to him, like with the, you know, Jeffrey E. or something to that effect. Because if he goes to prison for a while, they're going to somebody's going to hear his story. Someone's going to hear his story. He's going to tell his story. And who knows what this kid has to say? I mean, he definitely could be telling a whole big story. He might say, yeah, man, you know, my friends, my buddies, I met these guys online. I don't know what happened. And Barron made an amazing point. Just because a text message was sent to you, or you sent a text message, doesn't mean you sent that text message. Because I'm sitting here right now and I am texting from my phone, but guess what else can text? Guess what else can text as me? Guess what else? My iPad, I could get, my husband could take this and he could go camping and go on here and text message from my phone number and text anybody he wants as me from anywhere he wants, as long as he has this and my password. If I'm not home, if I'm out of town, he could get right here on my computer right here and pull up my text messages and start texting as me. Even though I'm not here, even though I could be in a whole other state, I could be in a whole other country, and he could be using my computer to text message from my phone. And so there, you know, that again, that creates reasonable doubt. Right there is reasonable doubt. You can't even trust the messages that were typed out and sent from his phone, because nowadays there's plenty of other things you could text from that isn't his phone. Maybe he has a text now number. Maybe he has an internet phone number that he's texting from. Anybody could have that. Anybody could log in as him and use that from any device in the entire world, anywhere at any time, as long as they have his password. And it doesn't take a genius to get that. So it takes a hacker could get that information. Somebody could hack in and steal his information. The feds could easily get that information and be logged in as him doing whatever they want. Tons of people. That's just complete and total, you know, nowadays that doesn't even matter if you have something like that. It's just, you know, it's crazy. That's such a reasonable doubt to me. That's why I have a feeling they're going to maybe take this to trial. And then he's going to get off, because there's just way too much reasonable doubt. That alone creates reasonable doubt. If he never sent those messages, then it, you know, because look, if the jury decides, say that message thing comes up and the jury goes, you know what, these could have been sent from any device, anywhere. Anybody could have sent these, right? That creates a little speck of reasonable doubt. And that alone should be enough to get him out of there, get him off for this crime. But then with that little speck, right? With that little speck of somebody saying these messages were probably could have been from anybody, then you immediately have to ask yourself, why would someone else send these? If it's not him, which it could very well not be him, why would somebody else send these messages? And then that's a huge, big, giant reasonable doubt you've got yourself into now, right? Because now you're going, well, if he didn't send these, then that means someone else did. And why would someone else? And right there, he's done. He's off. He's not getting, you know, he's not getting put away. And there's no way a jury can, I don't see it, at least not right now. At least not right now. Not yet. We still got 3 days left of seeing what evidence they have and seeing what they, you know, they're going to bring to the table here. But with all we've seen so far, there's been plenty of things that holster, reasonable doubt, right? That bullet, reasonable doubt. That gravel, reasonable doubt. That could have been anybody laying there. Just because there's an imprint doesn't mean it was him, right? The second weapon they found on the scene, that's reasonable doubt. The text messages, reasonable doubt. The Discord messages that were sent after he was taken into custody, potentially, we still haven't found that out for sure, but that's reasonable doubt. And so if any jury does convict this kid, then we absolutely, I will think myself 100% they were bought and paid for. I will think that 100%. And the sad thing is that just like with the Diddy trial, these jurors can then go on to write a book about being on the jury. They can make all kind of money off this. This is such a high profile case. If this goes to trial, the jury's going to be talking for years about this and making all kind of money. It's wild. My man has a friend in Utah City Jail who calls almost daily. I'm gonna have to ask him about Tyler Robinson housing situation. I'm curious. Yeah, I'd love to know that myself. I would love to know that myself. Makes you wonder, like, is he being protected? What's going on there? In my opinion, they made things very confusing, and Tyler was involved, but they told him he would not get convicted because they could not prove him guilty. Right? I think so too. By girl, I have a feeling that's kind of how it went as well. I think he's involved somehow, but I don't. I think he just played a small part in what happened that day, just to create more, nonsense around the whole thing to make us all focus on him. They're not providing exculpatory information, which they have to. All the exculpatory evidence has to be given to defense, and they're not doing that, obviously. Well, I mean, I guess they did, but not to us. Could be, yeah. That could be, Jen. I debunked the Discord messages on a live with Danks. Yeah. Well, see, with the Discord messages, there's like a gap in the evidence, though, because one paper says one time and one paper says another time or something like that, right? And so there's two pieces of evidence that kind of go against each other, and the sheriff saying one thing, and it's just a big mess. But yeah, if they do prove that he was taken into custody at that time, it's funny, though, they lost the video, right? They lost the whole video of that. It's gone. Disappeared. They didn't realize they would need that. They just forgot about it, and they were like, oops, we recorded over it. Like, our bad. Nobody requested it in the 30 days, so it just got recycled. Yeah, they were I believe they were created after he was in custody. Yeah, then he goes to France and lives with the Macrons. They literally have no real proof he did this because he didn't. Yeah. Again, you're absolutely right. If he did this, there would absolutely be proof somewhere, 100% proof, like beyond a reasonable doubt. There would be proof of it. And the thing is, to get that proof, they would have investigated everything. There would have been everything on Charlie would have been taken into custody. His phone, everything of Charlie's would have been taken, and all his clothing. All the people's clothing who drove him to the hospital. That vehicle would still be impounded and sitting there in evidence. They would have had a crime scene expert come out and go through that vehicle to find out what exactly happened in that vehicle in the moments leading up to this. There would be video from the hospital. There would be video of everything that happened to Charlie in the hospital. The doctors and nurses and staff would be, getting ready to come to the hearing because they would have to testify as to what actually happened to him. There would have been that whole section wouldn't have been dug up and paved over. That would still be sitting there, or at least it would have sat there for a good long while until they actually investigated that area. There would have been, soil samples taken. There would have been all kind of stuff going on over there. It's obvious they did not investigate this fully. They would have questioned everybody who was there that day. They would have questioned his wife. They would have questioned a ton of different things. That message alone that he sent to Joe Kent, that message alone would have sparked an investigation into foreign adversaries, or whatever you want to call them, which Joe Kent tried to tell people they need to look into that, but they just, ignored that. They would have actually done 100% really, really good investigation. They would have definitely, crossed their T's and dotted their I's on every little section of that investigation. And they would have found, if it was him, they would have found him. But now, because we see that they didn't look into hardly anything, right? They missed so many things. They missed all this evidence. They didn't even take that car. They didn't impound it. They detailed it and sold it. Like, what? Turning Point USA has the mic that he was holding in his hand when he was unalived with his blood on it. They have it on display. Erika Kirk walks up to it, rubs her boobs on it every few days in front of the camera. They have it on display. That shit would have been, taken into evidence, and it wouldn't be released until after a trial. Look, they won't even release 911 calls until after the trials. They won't even release body cam footage until after the trials and things like that, right? They won't even let us see that kind of stuff. Even if you FOIA request it, they deny it. But they can give her his phone back? What? Like mere days after this happened? Like what? Just like Trump fix it till he makes it, fix till he makes it. Trump creates his own reality and creates his world. That is what they're doing in this case. They're creating the story and only giving the information that follows. Yeah. And that's not really how you investigate things, right? You don't just pick a suspect and then only look at the information that leads you to that suspect. You look at all the information and then decide who your suspect is. But they're just doing the total opposite here. Yep. Trust the dogs over the feds. Yes, the judge needs to be for real and tell them we aren't going to waste time and state's money and time on this bogus child. Doubt he would. He will, but he should. Yeah. Yep. Dogs don't understand how to frame people. Yeah, honey, that's a great point. That's a great point. The dogs do not understand how to frame people. Oh, I don't know. He might have been Angela, but I'm not sure. The messages themselves are not Discord. The times are irrelevant because the messages are completely fake. Yeah, the text message things, those were just text messages. That's what I mean, though. They could have been, that could be sent from anywhere. Text messages aren't, and they're not giving the metadata. They're just giving pictures of things, pictures of a phone with a message on it, which could be from literally anybody's phone. I could type up the messages and make the names to go with it, and just, you could take a picture of my phone doing the same thing. Get a boost income. I don't know, but shortly after this all happened, somebody in one of the chats of the live streams I was watching right around then said that Lance's family's home got paid off. And I actually went and looked it up on the state website for something or other, but I did. I followed that and looked it all up, and yeah, it did get paid off. You can't prove who the money came from, but you can see that it was paid off very shortly afterward. And the fact that he's not even going to be at this, they can't even cross-examine him at this trial here, this little hearing. The fact that he's not arrested and somehow in trouble for, like, that's another big chunk. A lot of evidence disappeared. Yes, it did. Yeah, the screwdriver on the roof still managed to put it back together in the woods. Yeah, right. Exactly. If he had to do the whole thing with the screwdriver, how did he do it in the woods? Maybe he had one on his keychain, like a pocket screwdriver, I guess. I don't know. But I think it's weird that he would put it back together in the first place. Why would you? Why would you put it back together in the woods? Because it would make a bigger spot. If you left it taken apart and wrapped it up tight, it would be way smaller. So that literally makes no sense either. Like, why would he even do that? Yeah, I think he was a small part of a big plan. I agree. Yeah. Yeah. Yeah, it's a federal case, and they're sitting here in the state court. Grok thinks the messages were fabricated. That's interesting. Yeah, how is everything on camera except for that event? Exactly, Angela. That's such a good point, too. That's another great point. All these cameras, all this footage. You got footage from behind Charlie. It's crazy to me that, that 2 feet, 3 feet, that the camera was behind Charlie didn't capture him doing this. If there was a line of sight from him to Charlie, how is there not a line of sight from Charlie to him? 2 feet behind Charlie, that 2 feet just totally blocked that image. How convenient is that? Is that why they put Charlie up on a pedestal? Why'd they have him up in like on a shelf, sitting up on a fucking shelf higher than the table to make sure everybody could see what happened, I guess. Just weird to me because Nisi found out he was never up that high on any of his other things that he did ever. And then all of a sudden in this one, he's like way above the desk. Like his knees are as high as the desk. Like what? Why? That's weird. Were they higher than the desk? I think they were higher. Yeah, Tyler's life has never been in danger more than it is right now. Day number 2 has pushed it over the edge. I don't think he's safe at all because this is like so obviously the craziest cover I've ever heard in my life, and I have any evidence on him. Yeah. Yeah. Right. That's what I think. That's why he turned himself in. Yeah, if this isn't a conspiracy, it has to be the worst case of tunnel vision in the history of United States. I agree. Yes. What widow says, mic me up and video me rubbing my dead husband's cold, dead hands? I know I'm a widow. No one would. Yeah, nobody would. And look, even if you would take a video of yourself, over the casket of your loved one, you wouldn't post it on Instagram. You might take that video for you, just for yourself, or maybe in the future to show your kids. I don't know. You know what I mean? Just something maybe like that. I could even excuse that kind of thing. I could even see that because everybody's different, right? Everybody has a different way that they might feel about that kind of stuff. But literally no one on earth would post that on Instagram. Literally nobody would post that on social media, period. That is such a private, intimate moment, or it should have been private and intimate.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the FBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time, and we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
Oh shit, we got a new one. Drum roll. All right, where's this girl at? Come on, girl. Here comes the Fed.
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means evidence response team.
Yes.
She's already nervous.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was a
action?
bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody, then eventually it was provided to the ATF lab.
Okay, so the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31. That's connected to the defense computer right now. Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmouina can observe this exhibit. If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that in fact the report that you received documenting the testing results on these items and some other items from the
Yes.
FBI?
Sorry, yes,
And does it appear to be in an accurate condition as to how you received it?
yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objection.
All right, so I'll note the standing objection, and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burke? All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Sergeant Falmolina, do you see the lines that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
It's cumulative. We have the analysts here who can describe it. Not sure it assists the court to be having her read from the report that's already in evidence.
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right, the court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7, sub 1. Item 7, sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7, sub 1 and are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8, sub 1. Item 8, sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8, sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
All right, Mr. Burt, cross-examination.
I'd like to reserve the right to cross-examine after the witness completes their testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the party?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker. All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Ms. Baker, if you wouldn't mind being
This
seated at the
freaking
witness
court hearing is a joke.
stand.
Did someone's phone just ring?
Once
Oh
you're
my
situated,
God.
There should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we
Okay.
could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled B-A-K-K-E-R.
And Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files
Yes, I do.
and document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All. Spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says one of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in your report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay. And then the next one, not that one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Anything else?
I love how she said it's a human error.
Not that I can think of off the top of my head. One of the big things is potential human error.
Or
I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Or it might not be him.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go on to this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down.
Oh my God, is this actually for real? I can't even.
Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
Wow.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does the DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data?
Heaven forbid you brush up before you come to court.
So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Holy shit.
And what is
Oh
the
my
effect
God.
of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 7-10.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent
this
to
is crazy.
letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length.
Correct, yes.
Okay. Now, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct. And that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is it differs amongst us, with the exception of identical twins.
But with within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex type determining, so 24 total.
What are the sex determining, they're called locus, correct?
Correct. So locus is that individual section of DNA.
Right, and they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex determining locations. One is Y-indel, and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay, and then for the other locations you're looking at, those, you're just looking for 2 types at each location, correct?
Correct, yes.
Okay, now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations.
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes, so for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now, for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right. And then by the same organization, National Resource Council, the evaluation of forensic DNA evidence.
Correct, yes.
Published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing.
Yes.
Familiar with that. forensic DNA typing methodology
Yes, I'm familiar with that one as well.
and forensic DNA typing interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident based on our validation, our testing, and my training that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 1415, I will not automatically exclude them.
What is stochastic effects?
Stochastic effect.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning.
It's gonna be like
how far are you gonna
overruled.
Go on this line of questioning.
I have this one question and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAS report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST report is, PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
7%, and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of
Objection,
Investigation?
Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence of the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine.
Yeah.
So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state.
Oh,
And
robustly
I
sit
think
your
we're
ass
beyond
down and fuck off,
that
sir.
point now.
He has one more
Getting into
question.
the admissibility questions.
Quit crying.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to,
Well, we want to know if the DNA is reliable, Judge.
I will just leave it at
We
that.
just want to know, because that's
Are you familiar with that? Animals?
important, sir.
No, I'm not.
Okay. Just to close the loop on the PCAS report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
She knows everything else, but she doesn't know this shit.
But
Okay,
you do know
Mitch.
that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a
Whoa,
mixture
whoa,
of 2
whoa.
individuals.
She should have shut the
All
fuck up
Well,
right
that's
there.
the next thing I
He
was
said
gonna
yes
ask you
or
about,
no.
which is,
Did you know it?
what is
She should say
NOC?
yes.
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
Really, it's
But
not?
it
So
can
we
be
could
in
do
some
it?
cases, correct?
It could be if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same. It could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that a publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just make sure. That the, it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you,
You know, these fuckers
Same
talk for
objection, Your Honor.
45 minutes when it's their
This
turn,
is
asking the
beyond
dumbest
the
shit.
scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where again the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination, therefore irrelevant to this proceeding.
Thank you.
I want to know why it's irrelevant that the DNA evidence is trash. I would think that's very relevant. I don't get the point of why he keeps standing up and objecting, because when it's their turn to ask their 5,000 questions, we spent 4 hours with the last guy while they were talking about a map. That's southwest and 3 clicks to the north, sir. And yes, I could do that backwards and upside down and 4 clicks to the west, sir. For what, 4 hours? And now we're trying to find out about DNA. DNA. And it's like, objection, objection, objection.
Mr. McBride, Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these 2 samples.
Just ask her.
And so the
Who else
one
could
thing
be
the
a
court has
possible
to weigh is
contributor?
what is the weight of that opinion, given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And
Look at her putting her head up like, because I'm a genius. What he should just say is, how many other people on earth is it possible these could be a match to? Because obviously, if they're just counting boxcars on the DNA, I'm sure there's several people that have a 1714 and an 1111 or whatever the hell he's saying. There's probably millions of other people on earth. And all he has to do is ask her what's the possibility of that, and we could all move on. But he keeps going around the bush to ask her about all this other stuff and all these books. Like, we get the point. He's possible, but so are a bunch of other people. So are a bunch of other people. I guarantee it.
as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
Yeah, I don't
So,
like her head tilt either,
the
but her
concern
sweet.
that I
She needs
have
smacked in the
is-
face.
I turn to State
With
v.
some
Ramirez,
DNA.
2012 UT 59 in paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is
What cracks me up about this whole thing is, why doesn't he just call up 10 witnesses to go, yeah, you know what? I don't think it's Tyler's DNA on there, because the hearsay is fine. But when you got actual fucking DNA evidence sitting in front of them, they're going to have a problem, like, trying to determine what's what. Are you kidding me right now? He's literally going to argue about this DNA when he let every other stupid ass thing that wasn't even proof or evidence in any way, shape, or form come through. And he kept letting him talk and letting him talk. And we sat here for hours all day long. Now you got a thing that's actually concrete, could be concrete evidence. And he's trying to say, hey, you know what? The state is telling us this is this. And you know what? it's not really working out. And he's like, yeah, you know what? That's enough about this DNA. We want to hear again what Joe down the road's cousin said to his sister's mother-in-law about Tyler whenever, like, are you kidding? This is so guys, I've never seen something so crazy in my life. This is wild.
As a matter of fact finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate,
oh, fuck off,
I
Judge.
hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay.
He's
in
saying
addition,
it's not.
Credibility determinations are not proper for the court to make here for the whole reason that, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury.
Thank
in the
you,
end.
Elmer. Hello, Ella.
That all supports.
I'm not
cutting
sure,
this
Bittersweet, if
line
you
of
can hype
questioning off
lives.
at
I'm
this
not
point,
sure
rather
about
than going
that.
on for
I made a video. You could hype that one. I made a
into
video today
greater
too.
depth.
We missed. I don't think we didn't watch it because it was just right before the hearing.
Based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is
Thank you, Ella.
denying,
Thank you,
but
Ella.
sustain in the sense that this would be the last question, and
Yeah,
if
exactly.
Mr. Burt would chooses to, may go
Jen,
on to a different
exactly.
subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So
It's still not the same.
that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up to the witness?
Good goodness. Aw, thank you, Ella. That is very sweet of you. Thank you.
Let me know when you have that in front of you. I think you need to scroll up one page.
I wish you would just ask, like, what's the likelihood of anybody else having the same
There we
thing?
go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms, or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
So I move into evidence page 365, and that would be
Thank you,
Baker
cheesy.
4.
Thank you, American sweetheart.
Mr. McBride?
Yeah, I'll object on relevance grounds.
All right, did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability.
He literally
of her
already said
testimony.
he's going to get to this
All right,
place.
So as it relates to.
And he literally already made his ruling.
Baker 4, and this is,
Like, sadly, I think we could pretty much tell this judge is new, because didn't he just Didn't he just roll on this very thing and said, go ahead and finish out your questioning here, but blah, blah, blah. And this guy keeps objecting and the judge keeps thinking he has to give a new answer and redo everything. Like, bitch, no, he already said what he said. Let him finish. He's literally almost done. Good God.
Her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31. I will find that it is relevant and that it is admitted into evidence. As regards to publication, what is the request?
Your Honor,
Mr. Bird?
if I
Look,
may
he
clarify,
keeps
I think the
interrupting him.
testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that, from both sides. I want to make sure. I want to make
It's
sure.
both of
are
their
these
notes.
Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created
She just
after I
said
had
this.
already
She already said all this.
drew my own conclusions.
All right, I'm just trying to
Oh, for fuck's
put it
sakes.
together here.
Wow. I think he had some bad food for lunch. I think he ate some bad sushi or something and he's over here sick. He's like, and they got this idiot in the front row that keeps objecting to the same exact thing after he already said he was going to allow it. I mean, geez, oh man, at least that's how I seen it. Maybe I'm wrong, but that's what it looked like to me. Let's move along, Judge.
So the
we
question
all
I'm trying
want
to
to
get
go
to
home.
counsel is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer
He
to
said
just
it's
yet.
in her fucking report, sir.
Okay. Let me
I
lay
mean,
a more adequate
you gotta
foundation.
explain this shit. Listen, the judge,
case
sir,
file-
the judge has no idea what any of this means anyways. Literally. Honestly, this judge is so confused right now. He doesn't even know what this means. Even if she answers these questions and he's not going to know what the hell that means. He's literally doesn't have no idea. He's like, I'm really just trying to, what's DNA? What's this again? This isn't hearsay, so I don't know how to process this information.
Notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those two reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
So it's important.
In this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have one reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
Funny her head's not straight up in the air now, acting all snooty when we got to listen to how many people have to review her work before they sign off on it. Girl, you ain't that smart, or you wouldn't need 2 other people to oversee your work and agree with it.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
Yeah, like, come on.
Anything further from the parties before I weigh in on?
You already weighed in
make
on
my
this like an
ruling
hour
before?
ago, sir.
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
In both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, go ahead and publish that to all screens and maybe captured by the media.
So these notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3. So we had a discussion as to why she thought it was 2, why I thought it was 3. And she said she agreed with me calling it 3 based on our discussion.
Okay, so was that an extended discussion you had with her, or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it
we're
is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit.
Did he trick her?
No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different?
Uh,
The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
But there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine could there potentially be a third person included. So for example, at D2, the location farthest to the left, I'm asking myself that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use a phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twig should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So
Regardless, he's still on
It's
there.
different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
Because they live together.
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly. But in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
It's funny how
Any investigator ever
she knows
tell you
everything
that
but the stuff that
the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs' DNA to be present?
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up star mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It'd
to
be a
take
great
15?
time, Your Honor.
All right,
Thank
let's
you.
take a 15-minute
break.
Let's see.
Court is
We'll come
almost
back
over,
at,
bro. End it.
3:50. Court is in a brief recess.
End it. End it. End it. Oh my goodness gracious. Guys, I think this is a good place for us to call it a day today, because I'm pretty sure we're never getting through this. And even if we do, I think we very much 100% know what, what they're going to be saying here. They're going to be saying like, well, Lance's DNA was on everything as well. I think we've proven that. Now, will they admit this into court? Will he take this into consideration? Absolutely. Even after 3 hours of this guy proving his point that, he was a possibility, right? That Tyler was a possible match and that Lance was a definite match, but they ruled him out. I think he's going to take this into consideration and just, be like, you know what? Tyler's DNA's on there, even though, the way she's doing this DNA evidence, it was degraded, which I don't know why it would be if it was used so recently. If these things were used very recently, why would they be degraded? Why didn't he ask that question? Like, is it very odd to find an item that was used within the last 24 hours to be so degraded? Because I don't think it is. I don't think that's normal. She said it degrades over time. So how much time are we talking? You know what I'm saying? 24 hours is 24. Does it start degrading in 24 hours? I'm not really sure. And it wasn't even really 24 hours, right? I mean, she said they tested it within 24 hours or 48 hours. I don't know. All I do know is this whole thing is just a shit show every day. Every day so far. Well, for the last 2 days, it's been a shit show. Now, tomorrow it starts at 1 p.m. That's 3 hours later than it did today. So 11, 22. So I think that's going to be 2 p.m. Eastern Standard Time. No, if it starts at 1 p.m. for them, it's going to be, was it not? What time did they start? 8 or 9? I think they start at their time 8, my time 11. So if they're starting at 1, then it will be 4 p.m. Eastern Standard Time, I believe. I'm going to double check it, but keep an eye out for either 3 or 4 o'clock. I'll probably start around maybe 3:45, somewhere in there a little bit beforehand. I think, or did I have, hold on. I know I don't think I did. Let's see. Yeah, on Thursday. That's on Thursday. I have something. And tomorrow there was something, but I think it was earlier. Let me just check real quick to make sure I'm not going to interfere. Yeah, that'll be fine. Okay, so that'll work out just fine. Yeah, so it'll be around, I believe, 4 o'clock tomorrow. So between 3 p.m. Eastern Standard Time. So we'll probably start a little bit before that. Like 2:45 or so. But you'll see it on the thing. But make sure you have your notifications set to all because you don't want to miss a thing. And I will keep an ear out to see if anything else exciting happens after this break. But I seriously doubt that it's going to be anything that we don't already expect, right? We know Lance's DNA is definitely on all this stuff. We know that Tyler's DNA is a possibility on all this stuff. And we know that the DNA was degraded, which he's not asking the right questions as far as I'm concerned. Hopefully they will step it up at trial. If this does make it to trial, hopefully he'll step it up and ask some pretty good questions at trial if they keep this DNA evidence. It's just such a shit show. But we did find out some really important tea today, right? We found a whole bunch of new information. I think it's going to just get better as the days go by. So I apologize, it's so boring, but we did find out some stuff. It's just slow going. And I think, as it goes, we're going to find even more and more things that we didn't even realize were going on, right? And yeah, Baron will probably cover some of it every night, I would imagine, as it's going on. But thank you all so very much for spending the day with me. I appreciate you so very much. I love you all so very much. Please don't forget to go check us out over on Club Vatra and get into the Discord server. Come join the group chat. All right. Or if you'd like to become a channel member, or tip your lovely host before you leave. I love you all so very much, and I will see you guys on the next one.
Let's up on this life. Hit the like and subscribe. Leave a final word before you go. I hope you enjoyed the show. If you got a laugh, it was all worth it. If you didn't like it, I don't give a shit. Don't be a monster, hit the like. Help me out, smash subscribe. Turn on notifications, don't miss the show. Hit the like before you go. Don't be a monster, hit the like. Help me out, smash subscribe. Turn on notifications, don't miss the show. Hit the like before you go. Subscribe.